Okay. Good morning, everyone. Call our meeting to order. This is the hearing of Judge Serge Georges, and we are very pleased to have Governor Baker here to introduce our nominee. Welcome.
Thank you very much, Lieutenant Governor. And let me just start, first of all, by thanking you, members of the council, for being willing to be flexible and quick with respect to creating a schedule for interviewing and discussing the qualifications of our candidates for the SJC. The untimely passing of Chief Justice Gantz sort of threw a wrench into the fall schedule. And I think we felt it was really important that the SJC be fully staffed, for lack of a better way to put it, by the end of the year. But when we looked at the calendar, we were concerned about whether or not it would be possible for that to happen. And you folks have been terrific partners in working with us to come up with an aggressive calendar and a process for engaging our candidates during this fall season. And I just want to say, first of all, how much we appreciate your willingness to do that. With respect to Judge Georges, there are three things I would just want to point out. The first is he's a lot younger than me, but he has packed an enormous amount of professional experience into his career. And during the process of interviewing and vetting his candidacy, I had a chance to talk personally with many people who had worked with him, either in the private sector or in the public sector, in big law firms, in small law firms, who had worked with him in the Boston Municipal Court, who had appeared before him in the Boston Municipal Court. And honestly, I can't ever remember having so many people from so many different walks of life say so many great things about a particular individual. His former colleagues at Rackman and Sawyer, where he practiced after he got out of law school, which is a big Boston traditional corporate law firm, just couldn't say enough nice things about him. And many of them have stayed in touch with him throughout the course of the rest of his career. When you talk to folks at the smaller firms that he practiced at, the sentiments you get there are exactly the same. And when you talk to the folks at the Boston Municipal Court, the overwhelming commentary, not just based on his work with the drug court and his work in the civil sessions, but his work as well with the criminal court, is people just believe that this is a very special person who respects everyone, respects the law, and brings a tremendous amount of intellectual firepower and personal grace to all of his engagements and his interactions. And I'm sure he will tell you today that that has a lot to do with the way he was brought up. And that would be my second point, which is this is a gentleman who has a wonderful personal story. His parents, I think, as I said in my remarks introducing him to the public when we nominated him several weeks ago, his parents basically stayed in a 2-bedroom apartment in Dorchester because they wanted to send their kids to parochial school, and that was the best way they knew to make that happen. And I think he will probably tell you that he's a proud product of St. Kevin's and BC High. And I think in many ways that sense of service and commitment to one's fellow human beings is deep into the core of the way he thinks about his role and his responsibilities, not just as a professional, but as a person. And the third thing I want to mention, and I've said this before. In the history of the SJC, the number of district court judges who have actually made it to the SJC is just astonishingly small. 250 years of service to the Commonwealth, and I think the number is less than 10. It might even be less than 5, and I just find that to be honestly troubling. And I take some satisfaction in the fact that one of that very small number is current Associate Justice David Lowy. But this is a chance to put somebody who has presided over a drug court, who's been deeply involved in the busiest district court in the Commonwealth of Mass, in a position where he can engage his colleagues in discussions about how their decisions affect the actual practice and delivery of justice every single day in the working courts across the Commonwealth based on his own personal and professional experience. And I think in some respects, that's an incredibly important part of how this court, especially in this day and age, needs to operate, make decisions, and function. And as I've said to you before, I appreciate the kindness and the respect that you've shown to all of our nominees over the course of the past 5 years. And I will leave it to you from here to engage a very fine man and a terrific judge and a great candidate in a conversation about his qualifications to serve on the SJC. Thank you.
Thank you, Governor, for your introduction and to your comments to our members of the Governor's Council. We are pleased to welcome you here to this beautiful room, this great hall of flags, which represent all 351 cities and towns of our Commonwealth. And as the Governor stated, your personal attributes and character, your professional experience give you a seat at this table today, but it's also the people who you surround yourself that have given you this opportunity today. And I want to acknowledge your wife, Michelle, who is here in this room, providing you needed support over your right shoulder, your right hand for sure. And live streaming of this hearing allows your mother, Maurice, and your daughters, Olivia and Samantha, to be rooting from you from their respective viewing spots. And I know your father, who you were named after, is recovering and is rooting for you. And I would think in his mind, he's like, I hope my son doesn't screw up today.
Governor, I think I would agree with you on.
So, and you have obviously many friends and colleagues who are watching from afar and hoping for a really good day here with our Governor's Council members. Would also like to acknowledge and welcome Chief Justice Mark Green of the Appeals Court, proud grandfather. Now, I think 2 weeks ago, we heard about that good news right here in this forum. First Justice James Coffey from the Boston Municipal Court is with us. Dorchester Division and Judge Kenneth Van Daka is also here from the BMC Roxbury Division. And we also have U.S. Senator William Moe Cowan. You might not recognize him when he comes to speak, so he's in really great shape, and we're happy to have you here this morning. And you'll see for yourself when he delivers his testimony. I also have a few rules to share as we are in COVID times. I want to thank Grace Robinson and Dean Serper for this wonderful setup today. Just really great spacing for us all to be comfortable in this room. You know, the wizards behind the curtain are all behind these screens, providing us with the sound and visual aids to make this possible today. We want to thank everyone there. Obviously, the rules around face coverings, unless you're speaking, are to be adhered to, and no gatherings of small groups as you come and go from this room. For the hearing portion of today's event, we have a list of 4 people that Judge Georges has identified. They will be speaking I'm also informed that there are two additional speakers who notified the council, and they will be participating by WebEx. We have put out the word that anyone wishing to testify had the opportunity to do so in person, may do so on WebEx, or may have had the opportunity to submit a written testimony either in favor or not of this nominee. Everything is live streamed, which is beautiful technology, so everyone, the public, can feel very much part of this process. I'd now like to introduce our members of the Governor's Council. We start from District 1. We have Councillor Joseph Ferreira. District 2, Councillor Robert Jubenville. Morning. Councillor Marilyn Petito DeVanley from District 3. District 4, joining us remotely, not remotely, is here in person, Christopher Ianella. Good morning. District 5, joining us remotely is Councillor Eileen Duff.
Hello.
And also joining us from District 8 is Councillor Mary Hurley remotely.
Good morning.
District 6 is Councillor Terry Kennedy. Okay, so this is the order of the hearing. In a few minutes, I will read the governor's letter of nomination. We will ask you, Judge, to introduce your family that's here with you today. We will swear in those who will be testifying with an oath, and we will then hear from those witnesses speaking in favor, additional witnesses, and those that are not in favor of this nominee. We will open it up for questions from our counselors. We will take a lunch break around 1 o'clock, and mid-morning we will take just a stretch break. We will probably do that around, I will say around 11:15, or as needed by members of the council and by our nominee. So there's our letter from Governor Baker, dated November 17th, to the Executive Council. Dear councilors, I am pleased to nominate Serge Georges Jr. to the position of Associate Justice of the Supreme Judicial Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Signed sincerely, Charles D. Baker. Would you like to introduce your family?
Thank you, Governor. I would. Good morning to you and good morning to the members of the council. Over to my right is my wife, Michelle. Seated to her right is my mother-in-law, Janice Alves. Seated to her right is my brother-in-law, Michael Alves. And I'm going to introduce the other members of my family that happen to be behind my speakers. To the far left in the gray suit is James W. Coffey, who is the first justice of the Dorchester Division. To his left is Kenneth Fiandaca, one of the justices of the Boston Municipal Court and a close friend and family member. But to his left is Howard Cooper, one of the seminal people in my life and true teachers that I've always had. Seated to my far right in the far last, I should say, is Frank Fioricano, who I consider a brother-in-law. To his right is Rod Osborne, a close personal friend, and to his right, again, is a close personal friend, Hank Brennan. I didn't want to embarrass some of the speakers, but they are also close friends with Dean Perlman, Senator Mo Cowan, and Chief Justice Mark Green, who have been friends for a long time, encouragers, and just wonderful people in my life. Thank you for giving me the opportunity to introduce them.
Thank you all for coming, and I'm sure there are more on that friend list that would have liked to have been here in person.
Governor, he's kneeling. He's obscured by the photographer, but I almost left off my brother-in-law, Dana Price. So I thought he might have dipped out on me, but I'm glad he's here. Thank you.
Well, we're thrilled that you are all here as well. Why don't we stand and take the oath for those here wishing to present testimony to the Governor's Council, and those who are participating by WebEx. You could please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Thank you. Our first witness is the Honorable Chief Justice Mark Green. If you could please come forward. We welcome your testimony today.
Good morning, Lieutenant Governor and members of the council. It is a great honor for me to be here before you today, and I'm particularly honored to have been invited by my friend, Serge Georges, to testify on his behalf. I must confess up front that I feel a conflict of interest on a couple of different levels. First of all, as a general proposition, I prefer to have candidates appointed to the Supreme Judicial Court from the appeals court. As much as I hate to lose valued colleagues as I just have with Justice Wendland, I think the appeals court is a suitable proving ground for appointments to the SJC. In this particular instance, I am doubly conflicted because I had hoped to have Serge Georges come to the appeals court. And if there were a way that I could persuade you to have him stay with us at the appeals court rather than moving to the SJC, I would do so. But for many of the same reasons, for all of the same reasons that I wanted him to come to the appeals court, I would urge you to support his nomination. I first met Serge in late February of 2000 when I was still in the land court. I was assigned to the motion session, and there were a series of motions, about a dozen motions, that had been marked for hearing in a fairly complicated matter involving contested easement rights on a parcel of land in Aquinnah. It had been set off by partition from former Native American lands back in the middle part of the 19th century. And there were something like 40 parties involved, and the case was just frankly a mess. And it was clear to me that it required some strong intervention and guidance. And what began as a hearing on a variety of open motions evolved into what became a pretrial conference as I was trying to figure out how to set it on a track toward an ultimate disposition. Things went on for quite a while. We had all of the attorneys huddled around the sidebar in the old courtroom in the Adams, what is now the Adams Courthouse, and things got a little animated at times. By the end of the session, just about everyone had something to say, except for this young attorney who was there on behalf of Caroline Kennedy, who was one of the property owners affected. And so I asked Serge, I said, next time, Mr. Georges, try not to say so much. Just trying to lighten the mood a little bit because things had gotten a little heated. And without skipping a beat, he shot back at me saying, my client likes it that way. And I said, what, is she paying you by the word instead of by the hour? I was struck at that moment by his quick wit, his confidence, and his easy manner. Later on that year, Serge was second chairing a case while he was still at Rackham, and Brian Hurley was lead counsel on the matter. And I tried that case, bench trial, as all trials were at the land court. But it happened to fall, I think it started on a Tuesday, just a few days. I had a hernia repair surgery on the Thursday of the preceding week. And going into that procedure, I had asked my doctor whether I would be able to sit and hear a trial so early following the surgery. And he said, well, you may experience some discomfort, but there is no adverse physical consequence from doing so. The trial had been on the calendar long before my medical procedure had been scheduled. And so I decided, rather than to inconvenience the parties, to go forward with the trial. The medical advice was accurate. I didn't suffer any adverse physical consequences, but the discomfort was more than I had anticipated. And I found myself, as I was shifting in my chair during the course of the trial, experiencing shooting spasms of pain in my groin at multiple intervals. I pride myself on being fairly stoic, but I could tell that my facial expressions were giving away the pain that I was experiencing. And so at the morning recess, I asked counsel for both parties to come to the sidebar, and I just felt an obligation to explain to them that if they saw pained facial expressions during the course of their presentation, they should be assured that it had nothing to do with the presentation of their case. And they thanked me for that, and the trial went on, and I didn't really think much more about that until early in 2017, when my wife Karen came home, early in her tenure as a newly appointed Superior Court judge. She had attended an education program for the training and orientation of new judges, and she told me that story. Serge at that time had been enlisted to train new judges, and he told the story and told it from the side, of course, that I had never heard before. In fact, he and his co-counsel were terribly concerned that the trial was going very badly, because every time their witness would give an answer, I had this pained expression on my face. And he told that story to the new judges for the purpose of emphasizing to them that they need to be aware that their every mood, their every expression, their every action on the bench during the course of a court proceeding is on display, and they need to be mindful of the unintended signals that they may be giving to the parties that appear before them. And at that point, I was impressed by the thoughtful way that he had internalized that experience into his own judicial manner and conveyed it to other newly appointed judges. And by the way, he had no idea that my wife was among the members of the audience that day at that education program. I've been aware for some time of how thoughtfully and compassionately he has managed the very busy Dorchester division of the Boston Municipal Court, and I'm familiar with that court because, as you know, my recently retired dear friend and colleague, Sydney Hanlon, came from that court. She has been very proud to watch his development into a revered figure in that community. I also read with interest some years ago a column in the Boston Globe describing his compassion and understanding and the engagement he demonstrated in challenging a young defendant to take control of his life and get back on the right track. In mid-August of 2019, long before the pandemic made such things impossible, I had lunch with Serge to encourage him to apply for one of the upcoming appeals court vacancies. And I knew then that we would be losing Judge Agnes and Judge Hanlon, both greatly experienced trial judges, to mandatory retirement the following spring. And I needed to have another experienced trial judge to bring that frontline perspective that Governor Baker just talked about to our court. We have a number of former trial judges, but not as many, frankly, as I would like to see. I've also been looking for some time to add a judge with substantive real property law experience to help the court with such matters now that I'm more than 20 years, well, almost 20 years away from my own land court experience, and I have other duties competing for my attention. He seemed a perfect fit for the appeals court. I was delighted later to learn that he had submitted an application, and then crestfallen to when Bob Ross called me to tell me that he was going to be nominated to the SJC. He's a very special person, and I'm confident that he will be a very strong addition to an already strong bench on the Supreme Judicial Court. And so, despite my confessed conflicts, I urge you to vote to confirm his nomination.
Thank you. Thank you very much. I'd like to ask Councilor Devaney to lead the questions. Thank you.
Sure.
How nice to see you again, Judge. For people who don't know, it's been 19 years that we first met, and I voted for you, and one of my proudest votes, I have to tell you. And what I felt was, with all your qualifications, you were giving unique experience to the appeals coming from the land court. And I think in our history, it's the first time that someone went from the land court to the appeals court. So I want to thank you for your service. And going over the 19 years, you became a grandfather through the years, and just recently, a new granddaughter. And I really believe a father of sons should have granddaughters. So having said that, but Your testimony means a lot to me. I have such, respect for you. Now, can you tell me, you mentioned what the nominee was involved in. Can you think of something else that you saw him and were very impressed with his demeanor, his qualifications?
Well, I think a large part of being an effective and a good judge is being a good listener. Judges play a lot of different roles. They are teachers, they are deciders, but they have to be able to listen and to have empathy and compassion for the people that come in their courts. And nowhere is that more important than on the front lines of a busy community court. Both in terms of his manner, one-on-one and in a group, but also the stories that came back to me from Judge Hanlon, who was deeply invested in that community, about how revered a figure he became in such a short time, of making connections with the litigants and the members of that community who came before that court. And as I say, that story about how he challenged a young man who had gotten off on the wrong path, and someone with less patience, with less understanding, might have sent that young man on his way, never to be seen or heard from again. Judge Georges saw an opportunity to make a difference, and I think if you extrapolate that out to all of the people who come before a busy community court, you can realize the impact. I know that they are, much as I have expressed my sense of loss for the opportunity to serve with him on the appeals court, I know that in the Dorchester division of the Boston Municipal Court, he will leave a huge hole. But they are obviously proud to see him move up.
Now, what attribute do you see that that the nominee brings as a judge in the municipal court going to the Supreme Judicial Court?
Well, I mean, first of all, any trial judge, whether it's the Boston Municipal Court or the Superior Court, the Land Court, the Housing Court, the Probate and Family Court, brings that perspective of what really happens as cases move forward, what it means for judges who are looking for guidance to read an appellate opinion and try to implement that guidance into the operations of their busy sessions. But a busy session like the district court operates in a different way, even in the land court, where we had time to read the papers before going into a hearing. That's just not the experience in the district court or in the municipal court. And the judge needs to be able to step in, size up a situation, handle the matter, and then move on to the next one, or they will never get to the end of the list on that day. And I think having a lived experience, an awareness of what that means for the rules that we in the appellate courts set for how judges are to decide certain cases and to intervene with corrective instructions along the way. I think sometimes we lose sight of just how challenging it is for trial judges to manage the real-time obligations that they hold.
Well, I just want to tell you that I am so pleased that you are the Chief Justice. No one is more deserving. And I do want to mention Justice Agnes and Justice Hanlon. And if it's the last thing I do in my life, I'm going to get that 70 years changed. We're losing such wonderful people. And very proud that I voted for them, and they never let me down, and you haven't either. Because as I said so many times, I don't have a crystal ball. And sometimes the robes change the judges that I voted for, and they have let me down, but you never have. And this is quite a tribute for our nominee to have you be a witness. Thank you so much for coming.
Thank you, Counselor.
Counselor Jubenville.
Judge,
Good morning.
how's COVID affecting the appeals court?
It has been a challenge, but I'm pleased to say that we have been able to continue our operations largely without skipping a beat. We canceled the arguments in April and deemed those cases submitted on paper. But as soon as we got into April, we heard 6 of those cases by Zoom, and then we were able to scale that out, and we've conducted a full list of hearings in every month, May to the present time. I expect that we will continue remote operations. We've moved all of the staff off-site, set them up with hardware, software, and training so that they can be fully operational. And we have essentially a zero footprint in the building. We're keeping people off the tee and keeping people out of the building to limit the spread of the virus.
Do you think the Zoom is going to remain as part of the appeals court's handling of cases?
We're looking at that. At the moment, it certainly will continue so long as the pandemic continues. And we are looking at a variety of different possibilities of how we might use it. As good as Zoom has worked, as smoothly as it has been for our continued operations, it is not the same as an in-court hearing, and I think everyone would prefer to be able to conduct hearings live and in court when we can. But as I said, I spoke on a National Center presentation early in the pandemic about our experience with Zoom, and we were looking at that question going forward. We lose probably 4 to a half a dozen days of argument every winter to snow events. And in each of those instances, it is extraordinarily disruptive. We can never make the final call on whether to cancel a day of argument until the morning. By then, some of our attorneys may already be on the Mass Pike heading in or the Southeast Expressway, and we've got to reschedule either 6 pairs, or if we're running 2 lists that day, 12 pairs of attorneys for other dates. So if we could avoid canceling those days and simply make the call 2 days ahead of time if we have a significant weather event, and send out a notice to say our hearings on February 14th are all going to be conducted by Zoom. Here's the link. Stay home and be safe. I think that would be a great convenience and would make things safer for everyone. There may be other ways that we can do it as well. We will certainly be looking for input from the bar on what people would like to see.
I was recently made aware that our court system doesn't have Wi-Fi.
We do in the Adams Courthouse.
You do?
We had an opportunity. This was back before I became chief, when I was chairing the technology committee, and we identified a variety of different projects or wish list items, and basically worked up a set of specifications for each of them early in the term. And as we approached the end of the year and had some money left over, we were able to pull the trigger and get those executed. And one year, we had enough money that we were able to outfit the building with Wi-Fi. So we, the Supreme Judicial Court, have both a secure internal Wi-Fi and a guest network that's available for visitors while they're waiting to have their cases heard.
Is that the only court in the Commonwealth that has it?
I don't know the answer to that. We are looking right now. We've got a filed bill looking for a capital technology appropriation. I say we, the judicial branch, and we certainly, that's among the initiatives that would be a part of that, is to look at. We have to do it building by building, but I think the Wi-Fi throughout the judicial branch would be an important step forward.
Do we have the money to get it in throughout the state?
That's what the technology bond, one of the things the technology bond bill is looking to do.
Yeah, I think it's probably long overdue. I never realized that. Even I was up in Lowell, the brand new courthouse they just built and opened.
Right.
Doesn't have Wi-Fi.
Right. No, I think that that has been a critical part of our ability to streamline our paperless operations. The secretaries move the digital content into a designated folder, and then we use an annotation application on an iPad called Goodreader. I get an email from my secretary telling me that the files are ready for me to sync. I press a button on my iPad, and the content transfers over the Wi-Fi network onto my iPad, and we're good to go.
Is there a committee looking into getting it?
Oh, yes.
Are you in charge of that?
I'm not in charge of it. No,
I think you should be.
Thank you. I've got some other things competing for my attention, but I am actively involved. Chief Justice Gantz asked me going back a couple of years to assist him along with Court Administrator Williams and Chief Justice Carey to look at how we could make a comprehensive inroads on the trial court's technology platform. And I've been actively working along with them across that time.
And when are we going to go to a system similar to the federal court? We file, if everything is filed
Electronic filing.
electronically.
Yeah, no, we have the platform available. They are piloting that platform. They use the same portal through Tyler Technologies that the appeals court is using. But the trial courts are implementing it in stages in somewhat different ways. The appeals court has been doing mandatory e-filing now for a couple of years, and even before we moved to mandatory e-filing, the voluntary participation rate had gone north of 70% because of the convenience it provides to our litigants.
Yeah, I don't know how many years the federal court has had it, but it's been a long time.
Right.
It seems like our court system's got to be dragged into the 21st.
Well, stay tuned. We're working on it, and I think you'll see some changes and some improvements in the next several years.
Well, thank you very much. I think you're doing a great job as chief.
Thank you.
Any further questions from, yes, Council Ferreira.
We had presiding Judge Casey from the probate court in here, and I asked him, and he acknowledged that with the Zoom things going on, instead of doing 40 to 45 motions a day, they're down to 10 or 12 doing it remote, which has become a problem for some of my constituents not being able to get a trial date. Let's say one parent goes in for a restraining order and they get custody of the kid, and the other parent wants to challenge it or at least ask for some shared custody, and they're getting dates 4 months down the road so they can't see their kid. He wrote back to me this week saying that he did look into it, and it was in fact true. Some dates are given now for February and March, and he's trying to expedite that by getting recall judges to do DOR hearings and other things like that. Do you see that as a problem in your court, and do you have any suggestions how we can make the courts more efficient so that people don't have to wait 3-4 months for hearings to see their children or something like that?
Well, in the appeals court, as I mentioned before, we're conducting business as usual. I mean, we are doing a full list of hearings every single month, just as we were before the pandemic, and we're doing all of them by Zoom. They are going largely without a glitch, although inevitably, whether it's a bandwidth issue for one of the attorneys, we have occasional hiccups where the screen freezes or the audio kicks out. At this point, we've had enough experience with each of those issues that we can respond fairly quickly with minimal disruption. I'm sitting tomorrow, and I expect that we will conclude our session on time. The attorneys have reported that they appreciate the opportunity to have their case go forward at a specific time rather than having to cool their heels waiting for several hours in court. So if anything, I think we've heard a full list, and it's been more efficient. And the feedback we got, I had our clerk, Joe Stanton, conduct a survey of our users over the summer as we were looking at the possibility of having to continue remote hearings into the fall. And the responses were overwhelmingly positive, and that gave us the sort of confidence that we could continue conducting remote hearings if, as it turned out, it did, the pandemic required us to continue remote operations. As far as advice for what the trial courts could be doing, I think I would be on very shaky ground if I were to presume to suggest that. I harbor no illusions that the appeals court operates in a much simpler operating environment. We have no evidentiary hearings. We don't have witnesses. It is, and this is true, by the way, for appellate courts across the country. We're in the midst right now, yesterday and today, of having a virtual conference of intermediate appeals court judges, chiefs from across the country, and we all are doing more or less the same thing, doing oral arguments, full list with video conference hearings. But we are able to do that in a way that is much more logistically complicated for the trial courts.
Right. Well, thank you for your service to the Commonwealth.
Thank you.
Appreciate it.
Thank you very much. And thank you for the information about the improvements in the use of technology, both during this pandemic and then what will continue after. When we, as an administration, moved into the State House executive branch, and we're connecting up with our systems, we were wondering about the Wi-Fi, and soon realized that it was not Wi-Fi that was provided by the Commonwealth of Massachusetts, but was provided by the University Suffolk University. And we had been borrowing it for many years before. So we quickly adjusted that when we came in. So I'm sure there are many old structures and courthouses that face the same challenges, but clearly these times underscore the need to have the technology available for the delivery of services. So thank you for taking this on. You might have been volunteered for another committee. I'm not sure that you have enough room on your plate for that, but we thank you for your leadership and thank you for your time today.
Thank you.
We'd now like to call our next witness, Attorney Mo Cowan. If you could please come forward. Thank you.
Thank you, Lieutenant Governor. Honorable members of the council, Judge Georges, Mrs. Georges. I know they're not present in the building, but Miss Olivia, Miss Samantha, your family. It is indeed an honor to be here, to be back here today. And I'm delighted to have the chance to offer testimony in support of my friend Serge Georges and his nomination to serve on the Supreme Judicial Court. I have some prepared remarks that I certainly will offer, but if I may, if you'll indulge me, I don't want to bury the lead.
Okay.
2020 has been an extraordinary year, a year of great challenge for many, for most. We're 29 days away from concluding this year. Because of the pandemic, because of racial strife, social injustice, our lives have been turned upside down. We have all suffered great loss. And it is because of a great loss, the untimely early passing of Chief Justice Ralph Gantz, that we are here today in support of a nominee to fill another seat on the SJC. The lead I don't want to bury is, what a wonderful way to conclude this challenging year. By offering hope and the promise of possibility, by giving an audience to a tremendous leader, jurist, and citizen who wishes to continue his service for the people of the Commonwealth and provide a sterling example of the possibilities for every young man, young girl across the Commonwealth. The opportunity to speak on behalf of this good man, outstanding jurist and longtime friend is indeed an honor. And as I said, the chance to do so by returning to this august body, one with which I had the pleasure of working many years, makes the occasion even more delightful. I was not present when the man I know as Serge came before you 7 years ago and pledged to become the judge we now know him to be. Had I been with you on that date, I would have done what I hope to do in my remarks today, is describe the person whom you will consider for the highest court and explain why this is the right time for this gentleman to be called to serve on that court. Others today will describe in detail Serge Georges, the jurist. They who have served with him or appeared before him can state with authority the impact Serge has had on the Boston Municipal Court and all who have come before the court these past 7 years. To be clear, 7 years ago, you gave your consent and sent Serge to the trial court, believing his varied experiences in private practice as a criminal defense attorney, civil litigator, and community leader would serve him and the court well. Today, we know your decision of 7 years past has borne the expected fruits, and Serge Georges has been an exemplary judge who shows fidelity to the law and knows the impact of those laws on our people and our communities. Today, we know from every corner of our justice system that Serge Georges lived up to the promise and pledges and is ready to ascend to the highest court in the Commonwealth to make even more good on his pledge to you and all of us. For above all else, Serge Georges has shown that he is above all else, a servant leader committed to fairness, justice, and honor. But for legions of us who have known Serge well before his storied legal career brought him to this chamber, this is not a surprise in the least, for he is the same Serge we have known from our earliest interactions and witnessed at every stage of his life and career. Personally, I have known Serge for a quarter of a century, and he is today who he has always been. A big man with an even bigger heart and preternaturally disposed to doing what he can to lend a hand and make our communities better. Even though we are contemporaries, Serge and I met, I should note, when we both were babes in the legal woods. I count myself nonetheless among the dozens who claim Serge as a mentor and guide. As young lawyers, both learning the trade together, I always knew I could count on Serge to offer a sympathetic ear during those early days of practice. And as slightly older lawyers, a bit grayer or more bald, as the case may be, Judge Georges remains the great listening ear to the likes of folks like me and countless others. Like me, Serge was a first-generation graduate of college and law school, so he knew my challenges and I his. Yet Serge ever encouraged us to never allow those challenges to deter us and emphasize that our struggles and triumphs were valuable lessons that would steel and serve us and generations of lawyers who came after us well. Indeed, you would be hard-pressed to find many lawyers, particularly lawyers of color, practicing in Greater Boston, who have not benefited from the lessons Serge has offered. Whether from the bench, in the classroom, around his barbecue smoker, which produces delights worthy of awards, Serge ever is dispensing wisdom, hard truths, and encouragements designed to help us all be the best versions of ourselves. If this sounds familiar, it is because Judge Georges conducts himself similar in the courtroom, understanding that we all are works in progress. His humanity and generosity of spirit are what makes this good man the great judge you have come to know. Serge Georges is a people person. He has the innate ability to be comfortable in every space, and this has served him well. What has served him even better, as a friend, mentor, and judge, is his equal ability to make everyone he meets feel comfortable in his presence and their shared surroundings. No doubt, this also has been a large part of what has made him a successful jurist. Our district courts daily bring together all aspects of our communities, and often the most vulnerable members of our community find themselves standing before a robed figure who is elevated above them, holding their fate in their hands. When Serge dons that robe and becomes Judge Georges, he does so aware of this dynamic, recalling his own family's arc, their flight from the authoritarian rule of Haiti, their belief in the power of education and hard work, the power of redemption, and the importance of the rule of law to bring balance to a world often seemingly out of sorts. He remembers this and elevates those who stand before him so that they know that their case in that moment is the most important matter in the world. He knows the importance of making people feel seen and heard. This is the essence of justice: to be seen, heard, and to have your matters fairly adjudicated. This is the essence of Judge Serge Georges. Among the attributes I have long admired about Serge is his common sense approach to his work and engagements. Judge Georges, as you know, is not big on pretense. He tells it like it is and tells you what you need to know, not what you want to hear. This is important because we want our SJC justices not only to hear and challenge the litigants who appear before them, but to listen to and challenge each other as they debate and decide the issues that have reach and impact, often well beyond the singular cases they take up. Adding Serge's clear and bold voice to the court not only will lead to the well-written opinions with which we have all become accustomed, but also well-understood reasoning that reflects the understanding of how those rulings impact the daily business of our courts, and most importantly, the lives of the residents of this Commonwealth. In a past life, I had the high honor of advising a governor on judicial appointments, including 3 nominees to the Supreme Judicial Court. Each of those candidates, like every justice before them and every justice since, not only were excellent jurists, but each also elevated the court itself. This council makes sure of that. Respectfully, today is another opportunity for the council to discharge your sacred duty and provide the people of the Commonwealth with another uncommon servant leader who will add to the rich tradition of leading minds and justice champions sitting on the court. I would be remiss if I did not note that this is also yet another opportunity for the council to support the governor and lieutenant governor as they continue to ensure that the highest court in the Commonwealth is itself representative of the people of the Commonwealth. As a second-generation Haitian American and only the second Black man who would serve on the SJC, not to mention, as Governor Baker noted, that rare district court judge who would sit on the court. This nominee certainly will add to the rich tapestry that is becoming an exemplar for other courts across the land. Counselors, I respectfully encourage you today to provide your awesome advice and consent to afford this good man the opportunity to bring his humanity, generosity of spirit, and fidelity to the law and justice to the Supreme Judicial Court itself for the good of the Commonwealth. Thank you for this opportunity to address you, and I'm happy to take any questions.
Thank you for your heartfelt and important words. Yes, Counselor Devaney.
Welcome back.
Counselor, always good to see you.
Good seeing you. You look great.
Thank you very much.
Yep. And I've always said, very few men can pull off a bow tie, but Mo Cowan can.
You can say that as many times as you wish, Counselor. I'm happy to hear it. Thank you.
Well, you know, it was quite a tribute for you to be senator for us for that time, and I appreciate all your service.
Thank you.
You know, as a witness, you're not here for me to ask what you think or what your philosophy is. You're here to testify for the nominee and your involvement with this nominee. How did you ever, what is your first involvement with Judge Georges?
Well, as I noted in my remarks, Counselor, Serge and I go back many, many years, a couple of decades as young lawyers just getting started out in this business. And as a first generation lawyer, law grad, the first in my family to go to a four-year college, in those early days, I often sought out people with like experiences who could be friends and mentors. And we often think about mentors as people who are older than us and who have a lot more experience than us. But I have often found some of the most impactful mentors are people who've lived your same experience or a version of it and are going through some of the same things. So they have that proximity to what you're experiencing in that moment. And Serge has been one of those people through every stage of my career, Counselor, who has been such a mentor and friend to me, someone to whom I could turn, ask a question, seek guidance, and always be assured that I was going to get his best advice, his most honest advice. And as I said earlier, he would tell me what I needed to know, not what I wanted to hear. And that's the best kind of friend and mentor.
What do you believe that the nominee can bring to the Supreme Judicial Court from being a municipal court judge?
You know, when I served as chief legal counsel and worked with the JNC, we often talked about just the importance of selecting really qualified, empathetic, understanding, talented lawyers to serve as judges in the district court. Why? Because the district court is the venue, is the tribunal where most people interact with the court system here in the Commonwealth. And often the people who interact with the judicial system, the district courts, frankly, are some of the most vulnerable members of our population. So making sure that you select the right folks to don the robe and to hear those issues, as I said, with a humane and sense of spirit and generosity is critical. And someone like Serge Georges, who spent the last 7 years in the Boston Municipal Court, leading the drug court, you're going to have someone on the SJC who understands that those rulings that come from on high have real impact and understands how they impact the litigants, the system, those in the system, and will carry out his duties with that in mind. Because he's been so proximate to that work, so proximate to the people, I think we all can be assured that when he dons the robe of an associate justice of the Supreme Judicial Court, he will carry out his duties, certainly showing fidelity to the law and to the facts before him, but with a keen understanding of the practical implications of those decisions for everyone who's going to come before every other tribunal in the Commonwealth.
Thank you for that that explanation. In this pandemic, I'm particularly concerned about child abuse. And I have even asked Lieutenant Governor, when she's on TV, to give a phone number for people to call. I think that it's a time that we don't even know how it's increasing. People are out of work, they have drug problems, they have alcohol problems, they have mental issues. And I'm really concerned about that. And I'm concerned about how much information, how much education does the SJC about the juvenile court. Now, what advice would you give the nominee to get up to speed on what's happening in the juvenile court? Because 90% of these, people, the children that are involved, are minorities, and they're poor, and they're in the custody of the Department of Children and Families. And I'm opinionated, Mo, and I'm not a big fan. And so I'm just, if you could just, in your experience, what advice would you give this nominee to get on board about what's happening in the juvenile court? Now, I'm going to also add, which is a priority to me, and I'm learning, and I'm trying very hard to learn about foreclosures. And I am, it's so egregious. These are fraudulent foreclosures. And I do have a friend who is among those people. And these are these are my priorities that I want to see the SJC get involved, because I am getting calls from people that make me cry. These are people who have paid their mortgage every month, and the judges are not asking, who is the mortgagee? They think it's the bank, and it's some fraudulent entity that we don't know, and it's the federal versus the state. And I'm going to tell you, if this continues, the Commonwealth is going to be bankrupt because of all the homeless people we have that this has affected. So I'm going to get off my soapbox. I didn't mean to embellish that. But those are the two really priorities that I have about the juvenile court, about, the juveniles. Because, I'm thinking, if it wasn't a pandemic, if a child was being abused, they would go to school and the teacher would see maybe a scratch, or maybe the child would confide in the teacher. We have no way to do that with babies, but I'm just saying, I really am concerned from the beginning of this pandemic, and I have said it to the administration. So having embellished it too much, could you tell me what you what advice would you give the nominee?
Yes, thank you for that, Counselor. And if I may, I join you in concern about the impact of the pandemic, particularly the impacts that may not be as obvious because we don't see each other as regularly as we once did, and hopefully once will again. Something I certainly, as a parent, as a resident, as a citizen, former public servant, have given a lot of thought to, concern about. Certainly when I engage with my elected representatives, I talk about it as well. And I will give credit because I think this administration has done a strong job of focusing on those issues as we try to work our way through this pandemic. But the two in particular around the impact on children, certainly child abuse, but you could expand that to the impacts on the education of our youth as we've had to alter our educational practices and what's being lost during this period are of great concern, as are foreclosures and evictions. Your question was, what advice would I offer Judge Georges as he ascends to the SJC, or he and his colleagues, including the new Chief Justice and others? My advice would be simply for them to do what I know them to have done throughout their careers, both as practicing lawyers and as judges. which is not to limit their knowledge base to that which they had the moment they ascended, but to continue to be lifelong learners. Each of our Supreme Court justices that I know and know well, Counselor, are the kind of folks who know that a big part of their job and what makes them successful, what helps them live out the creed and the promise, the pledge that they make to you, is that they spend time learning what happens in the other courts that are within their jurisdiction. They do not sit and see the SJC as an ivory tower where they are far removed from all else that is happening across the Commonwealth and our judicial system. To the contrary, they appreciate the awesomeness of that power, that privilege, that responsibility. And they regularly commune with their colleagues in the other courts, not just the chiefs, but the associate justices across the Commonwealth. And more than that, they also commune with the other participants in the legal system. So my advice to Judge Georges would be to do what he has done, what makes him who he is to continue to learn. I think one of the realities of this experience is none of us expect that the persons you decide will sit on the court are fully formed and are complete. Instead, we count on them continue to be the kind of jurists and servant leaders who want to continue to learn, to be better, to bring their wisdom, experience, combined judgment to the work, to the issues before them. And my advice to Judge Georges would be to just continue that work, and that will make him an even better, stronger, and more complete justice.
Thank you for your testimony. It means a lot to have you here. It's quite a tribute to the nominee.
Thank you, Counselor.
Thank you very much for your time today.
Thank you, Governor.
Given your experience, your words are valued and appreciated. Thank you. It's always nice to see you.
Thank you, Governor.
Our next witness is Dean Perlman, Dean of Suffolk Law. Please come forward. Thank you for coming today. You had a short commute. Thanks for the Wi-Fi.
You're very welcome.
For a minute.
We're happy to be of service to the Commonwealth. Thank you very much for the honor to be here today to testify in support of Judge Georges' appointment to the Supreme Judicial Court. For approximately 20 years, Serge has taught as an adjunct professor at Suffolk University Law School, where I have the privilege of serving as the dean. During that time, he has shown a remarkable and unusual capacity to develop expertise across a wide range of legal subjects. He has modeled professionalism and integrity for our students, and he has inspired others, including myself, through his ability to so effectively and powerfully communicate the importance of the rule of law. For these reasons and so many others, Judge Georges is going to be a superb justice if he is confirmed. I'll start with Judge Georges' impressive command of numerous legal subjects. We typically ask our adjuncts, many of whom are judges, to teach one or perhaps two courses because of the challenges of becoming an expert in an area and being able to teach it effectively. We have asked Judge Georges to teach in 4 different areas, including evidence, professional responsibility, trial advocacy, and Massachusetts practice. In each course, he has excelled, regularly receiving among the very best teaching evaluations at the school. In fact, in reviewing his evaluations, I can safely say that he is among the best reviews that I have seen in my more than 20 years in legal academia. For his efforts, he won in 2 consecutive years the Honorable John Graney Off the Bench Award, which is named after former Supreme Judicial Court Justice John Graney. And that's a student-selected recognition given to an adjunct faculty member at Suffolk who exemplifies great expertise as a classroom instructor. In short, Judge Georges' ability to demonstrate mastery of so many subjects in such a way to communicate it effectively to our students speaks not only to his knowledge and his intellectual strengths, but also his rare ability to convey his understandings to others who lack his expertise. Another trait that we hope to see among our judges, especially those on the Supreme Judicial Court, is professionalism. As a sign of our high regard for his professionalism, we not only ask him to teach our professional responsibility course on a regular basis, but we have also invited him on 5 separate occasions to deliver the professionalism oath to our incoming first-year students during their orientation. Our selection of Judge Georges reflects our belief that his professionalism is a model to which all of our students should aspire. Finally, a third, but I believe often underappreciated trait we should want in our justices is that they inspire. Justices are in many ways ambassadors to the public on matters relating to the rule of law and are often asked to speak about the role of courts and the law at public and professional gatherings. I can't emphasize this particular point enough. In these uncertain times, when the public's confidence in legal and democratic institutions is shaken, the ability to communicate the judiciary's role to the public has never been more important. And I have rarely met anyone who can speak about these topics to audiences large and small as effectively as Judge Georges. It is difficult for me to imagine someone who could better explain the value of our judiciary and the rule of law to the public. In fact, reflecting the deep admiration and respect that I personally have for the judge and his ability to inspire others in this regard, Suffolk Law invited him several months ago and prior to his nomination to the court to serve as our commencement speaker next May. As I near the end of my prepared remarks, I'd like to share not my own words, but rather the words of the students who have had the privilege of taking one of Judge Georges' classes over the last several years. They can speak to his brilliance, professionalism, character, and ability to inspire better than I can. Here's what they have to say. These are all quotes. Judge Georges is truly an inspiration to anyone aspiring to make a positive impact on our future. I have never felt more encouraged and supported to be the best lawyer I can be than after Judge Georges' classes. I will be a better and more honest lawyer because of Professor Georges. Judge Georges' skill, professionalism, and encouraging attitude make this class truly unique. Judge Georges is an amazing professor for his ability to instill a proper sense of justice in us. Professor Georges is hands down the most caring and inspiring professor I have ever had. Professor Georges is one of the nicest human beings I have ever met. He inspires me on days that I don't think I can handle school. The world needs more compassionate and understanding people like Professor Georges, especially in today's tumultuous and ever-changing world. And finally, Professor Georges is the best teacher I have ever had, not just in law school, but in my entire life. In closing, I've had the good fortune, the great privilege, to know Judge Georges personally during my more than 5 years as the Dean of Suffolk Law School. And I can say that I know vanishingly few people who have Judge Georges' combination of legal knowledge, professionalism, character, warmth, and the ability to inspire. The Commonwealth would be deeply fortunate to have such a person as a justice on the Supreme Judicial Court. Thank you very much.
Thank you, Dean. I would say you got your money's worth out of this.
Oh, yes. He's promised to continue to teach, though.
I thank you for coming today. Counselor Devaney?
Thank you so much for coming. We wouldn't have had the opportunity to know about Judge Georges, what he has done in the academic world. And I think, and no offense to anyone, but I think the greatest endorsement is from the students. And I have said it over and over, and people are tired of me saying it. I don't vote for anyone who doesn't have compassion and empathy. And these students have said he's compassionate and he's caring, best teacher in their lifetime, and to be encouraged and supported. I think what a wonderful attribute. So I'm so glad that you came, because I would have no idea. He certainly wouldn't have told me, and I met with him, and he doesn't talk about that. And I hope he will continue teaching. So thank you so much. Your testimony means a lot to me.
My pleasure. Yes, humility and modesty are other attributes that he has.
Right, that's true.
Okay. I do not see any further questions for you, Dean. Thank you for sharing your testimony today.
Thank you, Lieutenant Governor.
We have an additional witness selected by Judge Georges, Attorney Howard Cooper. If you could please come forward, and thank you for being with us this morning.
Good morning. Governor, councilors, it's a privilege for me to be here for the second time to support my friend, my colleague, Serge George, to be a justice to the Supreme Judicial Court. It's also a privilege to follow the three prior witnesses, each of whom is a legal luminary, and I suspect you're less familiar with who I am and why I'm here to comment on Judge Georges. I'm just a practicing lawyer. I've been in Boston practicing for over 30 years. My practice includes trying cases from the state district court to the federal district court, arguing in the appeals court, a couple of times even in front of Justice Green, and the Supreme Judicial Court, where I hope my friend and colleague Serge will be sitting. And I have been in the trenches for 30 years plus, and for part of those 30 years, I was in the trenches with Serge George. In the early 2000s, after he left Rackham and Sawyer, Serge came to a firm that I, with a few other colleagues, founded called Todd and Weld, which is now a much larger trial practice firm, but back then was really only about 20 lawyers. And I didn't know Serge prior to then, but I found myself preparing a case with him. He was my associate. I was the partner on the case. We were preparing a case for trial. It was a real estate dispute involving a boundary issue, as a result of which someone who wanted to build a Dunkin' Donuts in Roslindale couldn't put in a drive-through. And Serge and I got into a room to talk about the case, and let's just say that I'm not always the easiest person to work for. And I was extremely tough on Serge about how we were going to prepare this case. And his reaction to my being tough on him was to tell me that he wanted to learn from me, that he was invested, that he cared about what he was doing, that he wanted to be the best possible trial lawyer that he could be. And from that moment on, for the next many years, Serge and I spent time working together. Even after he left our firm to set out on his own for a bit, we continued to co-counsel cases, both on the civil side and the criminal side, and he became a friend. And I began learning from him. And when he applied to become a district court judge, I came before this council and I said, I cannot think of a better person to sit in the district court who will bring all of the attributes that you've heard others talk about this morning, not just his intelligence and his work ethic, but first and foremost, his integrity, his compassion, his humility, someone who grew up as he did and has had the life experience that he did, to be the person in that court to interact with the public. After all, that is where most citizens of the Commonwealth come into contact with our justice system, is our state district courts. So I believe Serge has lived up to everything we all said about him 7 years ago. And I will confess that this summer, as it became publicly known that there were spaces on the Supreme Judicial Court, it wasn't that I heard from Serge that he was interested. I called him and I begged him to apply. And I begged him to apply because I couldn't think of anybody who would be more qualified, who would bring a more important life experience to the Supreme Judicial Court than now Judge Georges. And it is my privilege to be here today to support him. I'm happy to answer any questions, but those are my prepared remarks.
Thank you. I'm sure that's a teachable moment that you will always remember from a a boundary dispute to a lifelong friendship and mentorship. Thank you for sharing. Attorney Kennedy.
You said that you weren't the easiest person in the world to work for. I hear otherwise from someone I talk to on a daily basis. Is being an associate for you a pathway to greatness? Because I hear there's someone else in your firm heading in that direction. My daughter was. I'm kidding.
Well, your daughter is a very fine person and a very fine lawyer, and she is destined for greatness.
And she says that she really enjoys working for you, and she's certainly learning a lot.
I've mellowed over the years.
I appreciate your kindness to her.
Thank you.
Councilor Devaney.
Thank you. I remember you 7 years ago, and thank you for coming again. I appreciate your testimony.
Thank you very much, Counselor.
Okay, I think that is it. Thank you, Attorney Cooper, for being here today. I'm sure it was an honor for you to come back again for your friend. There are additional witnesses that would like to speak in favor of this nominee. They are participating via WebEx, and we can begin by recognizing Attorney Howard Cahalis. I see you there, and we'd like to welcome you, Attorney Cahalis. The floor is yours.
Thank you. Honorable Karen Polito and members of the Governor's Council. My name is Howard Cahalis. I've been a lawyer in the Commonwealth of Mass for longer than I want to admit to. I'm here today to speak to the character of Serge Georges, the Governor's nominee to the Supreme Judicial Court. I have some words that I wrote down that I'd like to share. Who in this group ever got a call from a stranger just to tell you he liked an obituary you wrote? Surprisingly, this happened to me, and it was the most fortuitous call I ever had. When my cousin David Cahalis died several years ago, I wrote an obituary in the Lawyers Weekly, in which I recounted personal and professional stories.
We cannot hear. Hold on.
Unmute.
Is it muted?
No.
Okay.
We can hear you now.
We can hear you.
You can hear me now. Okay. Shortly after it was published, my secretary in the office told me an attorney from Barron and Stackfield was on the line. I picked up the phone, anticipating some legal issue about to unfold. It was Serge Georges, an attorney who I never met or spoken to before, who told me he felt compelled to reach out because he was so genuinely moved by what I wrote about my cousin. The warmth of the person on the other end was refreshingly genuine. Serge told me he was sorry for my loss and that obituary was so moving to him that he felt he knew my cousin and he had to reach out to me. This was high praise from someone I've come to see as constantly articulate. Perhaps a year or so later, Serge George and I were formally introduced at the Suffolk Law Alumni Dinner by our mutual friend, the Dean, prior to Andy Perlman, Camille Nelson. We immediately bonded and developed a true relationship and friendship. A colleague later reported to me, while in Dorchester District Court, where Serge was presiding over the drug court, my colleague said he was so moved to tears by the speech Judge Georges made to the graduates of his drug program, and especially when he came off the bench to hug each one of them. Serge and I have interacted on several other occasions, including working together to judge the Suffolk Law moot court competition. He has been to my office, to my home, with his wife and his adorable daughters. Watching him with his own children demonstrates his commitment to family. He embraces his role as a father and mentor, and it translates to the youthful offenders that appeared in his courtroom. Having practiced law for 47 years, I have never met a more compassionate judge or finer attorney than Serge. Once when we had a dinner party at my house and the discussion turned into political, It was quite clear Serge was speaking on a far different level than all my educated guests. He referenced laws and precedents. He confirmed what I already knew. Here is a man whose academic understanding of the law is equal to his respect for it. The humble circumstances in which Serge was raised have informed his life. He is exactly what you see, a child of immigrants who appreciated the hard work of his parents and in turn worked to show them that all their efforts were well received. There is no doubt that Serge Georges will leave a lasting handprint on the Supreme Court. He is uniquely capable of creating a fairer and more equal Commonwealth. He will serve with keen intellect and well-honed humanity. We all won with this appointment. I urge the members of the Governor's Council to approve this outstanding nomination to the Supreme Court in Massachusetts. Thank you very much for allowing me to speak these words, because I am in Florida, but I said to him I didn't want to miss this opportunity to tell the Governor's Council what a great person Serge is. He's a great lawyer, a great judge, but even a better human being. Thank you.
Thank you so much, Attorney Cahalis. It is a pleasure to have you and to see you in good health, but your sincerity and your desire to deliver those remarks today is clear to all of us when we thank you for sharing that story with all of us. I'd like to recognize Councilor Iannella, who has a comment or question for you.
Thank you very much. Lieutenant Governor, sorry to let you know, I'm not sure if Attorney Cahalis is in good as health as you just indicated. I saw him a week ago. How's the knee, Howard?
No, the knee's good. I've been rehabbing it at Kennedy Brothers at 45 Franklin Street, and I'm back to running. I only had a 3-week hiatus.
Well, that's good. That's good to hear. I have a great deal of respect for Howard. I've known Howard, a long, long time. My father and Howard's father served in the legislature together. I knew Howard when he was selling the ice cream in Nantasket. So Howard and I go way back. We've gone to the Celtics games. Way back we had season tickets, but great deal of respect. Your testimony was very compelling. Hope to see you soon. I am going to call your wife Judy and wonder why I wasn't invited to that dinner party.
But, listen, by the way, you have something in common with a prior witness, too. I sold Howard Cooper ice cream, too, and his whole family in Newton.
All right. Well, it's good to see you again, Howard.
Thank you very much for the opportunity to speak on behalf of Serge.
Councilor Jubenville also would like to comment.
I just want to indicate that I remember you from your old DMC days. You've come a long way since then. You've been very successful as an attorney. And yeah, Chris and I went hungry that night. You had the dinner, Howie.
Well, we'll have to invite you next time, Bob.
All right, you're on.
You're making us very hungry, Howard, between dinner parties and ice cream. You'll have to make up for this another time. So we thank you. Go in good health. Please say hello to Judy from all of us.
Thank you very much.
Thank you. We'd like to now recognize another witness who would like to present via WebEx. His name is Attorney James Krasnew. Attorney Krasnew, please proceed. We are unable to, here you go.
Okay. Are you able to hear me?
We can, yes.
Excellent. Thank you very much for giving me the opportunity to speak on behalf of Judge Georges. Like Attorney Cooper and Cahalis, I've been around the Commonwealth for some time. I think I may beat them both. I'm in my 56th year of practice. I've done entirely litigation as a small town and small time attorney in small firms. I have been in countless numbers of state district courts. I'm mindful when the book Courthouse of the Commonwealth first came out, I once took an afternoon to look at it and was stunned to see that I had personally been in all of the courtrooms pictured but for 4 in the Commonwealth of Massachusetts. And I have been acquainted with numerous district courts and numerous district court judges. I did not know Judge Georges until I began a case in the Dorchester District Court in 2017, and he finally was the judge on the case in 2018. The case, although it was a district court case, was a very complicated case involving several evidentiary issues. It involved several complicated problems, and he took over and was especially assigned on it and held that case all the way through till trial. He's a very unusual district court judge in many ways, some of which you've already heard, and I will try not to echo in depth the several remarks that have been made by previous witnesses in this case. First, several times our case was going to involve a lengthy hearing, and therefore he took care of business in his courtroom before that of shorter cases. I was able to watch him interact with other attorneys countless numbers of times. I was able to watch him interact with criminal defendants, both incarcerated and unincarcerated, both persons of color and not of color, persons who were disabled. It was amazing to me the constant empathy and respect he showed for every human being in his courtroom. When he was late on the bench and we were waiting for him, the first thing he did when he came onto the bench was say, "I apologize for being late." And he would give a short explanation of what caused the lateness. I can tell you that most district court benches that I've seen, when they come on the bench at 9:30 or 9:45 or 10 o'clock or later, offer no explanation at all as to why they have kept a courtroom of 50 attorneys and 40 people waiting. And he does that over and over again. How do I know that? I appeared before Judge Georges approximately 12 times in that one case over the period of time. Secondly, his attentiveness to the facts was amazing. He did run his courtroom with celerity, but never without paying attention to the necessary detail and effort required for each case. And again, I had the opportunity to see that because very often I was the last case called, and I knew that I would be the last case called because of the complexity of some of the issues we were dealing with, especially during the motion in limine sessions. I had filed a total of 7 motions in limine. The Commonwealth filed a total of 4. There were oppositions back and forth. He had to explore those and deal with those. But if that were all I were telling you about, that would not necessarily let you distinguish him from the other crowd of the Dorchester District Court or other district court judges that exist in the Commonwealth. Judge Georges was exceptional for several reasons. First, because the case had been old by the time he got to it, well over a year old. He decided that he would undertake the motions. Not only did he hear them, but he indicated that he would be writing written opinions on them. And to accelerate the problem, because my office was in Andover, and this was Dorchester, and pre-COVID, it was 1.5 hours down in the morning for a 9 o'clock session, and 2 hours if we left after 1:30 to get back through the Southeast Expressway. Mindful of that and mindful of the cost to my client, he decided that those written decisions would be emailed to my office from his office directly and to the Commonwealth. And that was an accommodation that he suggested as an accommodation to me and my client. But I want to point out one instance that is really exceptional, and I have, by now, I would say I have had literally thousands of cases in state district courts in the Commonwealth of Massachusetts. And I can remember only 2 other instances where this occurred. In one of the motions, it involved authentication of WhatsApp. And the only case back then, we've had several now on authentication of electronic media, but the only case back then that existed was the Supreme Judicial Court case of Commonwealth versus Purdy. And although it set out the governing rules in general, it did not apply in any way specifically to the issue that was presented before Judge Georges. And I wrote a memo reciting Massachusetts law. The Commonwealth wrote a memo reciting Massachusetts law. Judge Georges, on his own, not satisfied with the guidance of Purdy because it was incomplete and not terribly applicable to our case, went on his own and did research and came up with the precedent case out of the Supreme Court of Maryland that has been used quite often as the seminal case going off into the area more applicable to the issue before us. And he presented it to us in a hearing and invited us as a result thereof to write further memos if we wish to. That is extraordinary in a district court pressed for time that he would take his own time to research an issue. It was extraordinary that he would give us the further opportunity to work on the matter as opposed to using the research he found simply to make the decision. And most importantly, it showed me that he was not content just to rely on his own research, even though it was adequate enough. He wanted to be sure that what he was doing was right, and he invited the lawyers whose interests in the case were paramount to contribute whatever they could. Now, that really advances the law. It enhances the law. It enhances him as a human being. My client never for one moment felt that he walked out of that courtroom without a fair shake or without a fair hearing or being understood by the judge. And I could see from the look and expression of the countless other people who appeared before Judge Georges that they felt the same way. That's the essence of what he will bring if you provide him the opportunity to do so. That's the essence of what he will bring to the Supreme Judicial Court. He listens. He asks piercing questions. He is willing to do research on his own. He constantly has as his beacon to lead him through the tunnels of the law the belief that things must be fair, that fairness is an essential element of justice. And further, he has never forgotten his roots. When he was nominated, I learned for the first time that he's an old Dorchester boy. So am I. We share the commonality. And I think it's built into the soil there that you can't grow up in Dorchester without having real empathy and feelings for the fellow human beings that are your neighbors who may not be the richest persons in the world and encounter difficulties that you try to help them out of. He's really an amazing product, both from his parents and from his own teachings, and obviously from the quality of the friends that he has brought there to him. I do not know him in that way as a longtime friend. I wish I had that opportunity, but I felt after all my years on the bench, I felt qualified in a humble way to evaluate his spectacular performance and bring it to your attention because I felt that was important. Thank you for the opportunity to present that to you.
Thank you very much, Attorney Krasny. That was very compelling to articulate the quest to get it right and all that goes into that. You did a beautiful job expressing that, and we thank you for that. Councilor Jubinville.
Jimmy, thank you for coming in and telling us about that case. When you called me and told me that story, I thought it amazing that you really didn't know the judge other than being in a courtroom with him. And it really was a powerful story, and I just thank you for coming in and telling us that. Appreciate
You're
it very
welcome.
much.
Actually, it's my honor to present that.
We certainly felt that here in this room. We thank you. Do not see any further questions for you, Attorney, so you may continue to observe this proceeding if you would like. We thank you for being here today. We have additional individuals who would like to offer testimony. They're neither for or against the nominee. And we can begin with Judith Picciotto. Judith, you may proceed.
Yes. Oh, thank you. Good morning, members of the council. My name is Judith Picciotto. I live in Salem, Massachusetts. I'd like the courts to come forward and address you with their information and concerns. I really wanted to speak at Chief Justice Spudd's nomination to be the top leader of our highest courts, but I was not feeling well. But I expect she will get to hear this anyway. I warn you, I have personal injuries that make it difficult to do this, but I will do the best I can under the circumstances, so please bear with me. As I told the screeners, I am here to speak neither for nor against any of the nominations to our state's highest courts, but as a citizen with a great deal of experience with the Massachusetts courts, with concerns that they and this council need to hear. Also, I don't want to take up too much of your time, but please know that I speak on behalf of more than a dozen attorneys who would like to speak out as well, but dare not complain. I am here for them, and you are about to find out why. This may not be the best presentation to you, but I assure you, if I'm allowed to finish speaking, it may well be the most important one. First of all, I am not feeling very well. So for that and a number of other reasons, I ask that you please give me uninterrupted time to present you with my important information and concerns to Justice Georges. I and anyone listening to this can understand why you would want to immediately interrupt or ask questions, but I ask that you please allow me to finish, after which I will be more than happy to take any questions you have. I am grateful, truly grateful, of all the places in the world to live in this kind of democracy that does this. But if I asked you, what country in the entire world do courts, one, allow the trial judge, and the operative word here is allow the trial judge to withhold critical evidence that would expose that the fee-seeking attorneys are intentionally lying to a jury. Now, this is otherwise known as perjury, in order to cover up their malpractice and enhance their fees. Two, allow the trial judge to interrupt a defendant's trial attorney while she is presenting her case to the jury in order to interject and provide the jury with his or her own false statements of material facts and tell the jury that that attorney was wrong about her facts, and then deny the attorney's request to be able to brief the issue in order to correct the judge's, and I'm saying knowing, because he knew what the pleadings were, misstatement of material facts to the jury. And then order that same trial attorney to be put on the stand to testify against her own clients in that same trial in which she is defending them with no right of cross-examination as a means for fee-seeking attorneys to intentionally mislead the jury and thereby all but guarantee that they will win. And in what country do courts, think about this, which country do courts allow jurors to come to court dressed up in costumes such as priests and nuns and judges and stoplights and circulate a cast list as to who is going to play whom in the movie about the travesties that are going on inside this court of law? And in what country do courts allow fee-seeking attorneys to make secret payments to influence the testimony of a key witness while withholding the knowledge of such payments from the jury? And finally, last but not least, and actually it's not last, I don't have time for all the other stuff, neither do you, but in what country are they allowing fee-seeking attorneys to gift the jury over the objection of the client's counsel and then alter or destroy the court-held trial tapes in order to cover it up? If you guessed Russia or any third world country, you're wrong. The only place and I assure you, at least a dozen other disgruntled attorneys know of, when I say other, I'm not an attorney, I was the client. But attorneys know very well that the answer is the Commonwealth of Massachusetts. And I have sworn to such clearly unacceptable travesties and more in my sworn affidavit to you. As you know from the materials sent to you, the first of which is my sworn affidavit, with supporting documentation. And that's not all the documentation. I kept it to a minimum, but I documented it. And the second of which is a 12-page collection of quotes from lawyers, court employees, judges, and other legal professionals. The nature of those complaints is best summed up by the words of the Dean of a Massachusetts law school, Dean Lawrence Velville, on page 4 of those collected complaints. As far back as 1997, Dean Velville complained to the legal community that he is experiencing a, quote, rising crescendo of complaints over the legitimacy, even the honesty of the judges themselves. He goes on to state that despite the existing laws and protections of the public, he himself sees that, quote, judges function more to protect the wrongdoers than punish them. My affidavit is a perfect example of that, but I am not here because of what happened to me and my family under the above conditions. I am here because of what happened to me, because I am here because we are a few of far too many others who are being subjected to it, as you can see by reading the materials I bound for you. As set forth on the first page of those bound complaints, after investigation, the Center for Public Integrity, in partnership with Global Integrity, ranked Massachusetts at the very bottom of their scale for judicial accountability and gave the state an F. That F was given because the same court leaders who make public speeches asserting that the Massachusetts courts serve as a role model for the rest of the world are in reality turning their backs to their duties of oversight and allowing the most highly placed of their friends and court insiders as, and here I'm going to quote a former court employee that is identified on page 3 of that complaint, to make use of the courts as a, quote, a veritable criminal enterprise that responsible oversight, I'm still quoting, refuses to address, in which, in the words of another attorney that's on that same page, attorneys are more likely to get in trouble for reporting attorneys who are stealing from their clients than are those who do the stealing. End of quote. That former court employee goes on to state what other legal professionals assert and why I am here alone instead of waiting in line after a dozen attorneys who are even more concerned than I am about what goes on in our courts, and I'll explain why that is. Quote, this is in your complaints, and identified. The speakers, the people who wrote this are identified. If an attorney reports attorney misconduct, they stand the risk of losing their license to practice law for daring to tell the truth. That public complaint matches almost word for word the complaints of 2 other Massachusetts attorneys also on page 3 of those quotes. Quote, if they speak their minds, if they tell the simple truth, if they criticize a judge, they'll be investigated and risk losing their license to practice law. But I take you to the last line, which I have witnessed for myself. Absent the proper oversight, they also feel perfectly free to use the courts as vehicles for, quote, this is from a court employee, the framing of innocent citizens. And I think I should repeat that so nobody misunderstands what I've said. It's very important. The framing of innocent citizens. Quotes end on page 12 with the words of Judge Jones, stating that she herself also sees an ever-increasing use of the courts in which, I start the quote, lawsuits are wielded as weapons of revenge in which attorneys seem uninhibited about making misstatements to the court or their opponents or destroying or falsifying evidence. And she also points out that absent the necessary oversight, the misbehavior feeds on itself and debases the rule of law. Insider attorneys are allowed to give juries testimony that enables them to steal their clients' homes, their business assets, and their decades of lifetime savings, entire personal injury settlements, and the entire estates of extremely vulnerable elders are considered easy pickings. And I know for a fact that clients who dare to stand up to their behavior are subject to threats of arrangements for court-appointed guardians to take over their financial affairs. And even just as that court employee said on page 3, create false criminal charges if the injured parties don't acquiesce quickly and quietly to their unfair demands. And I have a legal transcript from my answering machine, legally recorded from an investigative reporter asserting that she has verified everything, as has her editor. I'm not making this up. And the short background of my case, so that you understand how far the courts are going these days. The short background of my case is set forth in my sworn affidavit, which I gave to every member of this council. As far back as 1983, my family suffered what insurance carriers call large loss serious injuries with damages in the millions. We owned an automobile business next to a leather finishing plant that suddenly began to emit highly toxic chemicals over our family business. Many people were affected, many. But my husband had it the worst. He spent years in pain on full Social Security disability and ultimately died from his injuries. Thanks in large part to fines and at least 62 citations from the DEP, that's the Department of Environmental Protection, the finishing plant was easily found guilty at trial. That trial was in 1993. But instead of paying the judgment, they hid their existing $100 million insurance policy with the coverage and staged a multi-million-dollar phony bankruptcy instead. Now, for those who don't know, with the prospect of more than 80 creditors going unpaid, doing so gave not only the polluting finishing plant, but their insurer financial benefits in the millions. However, my family was provided with highly credible inside information that the bankruptcy was staged. And as creditors, we tried to exercise our rights to get into the books and records of the debtor right here in Boston. But we went through a series of 3, and actually maybe 4 attorneys who billed us out of our judgments and then abandoned us, insisting there was no bankruptcy fraud and there was no insurance as we were insisting. So, as creditors, having no money, it's all gone, we, my family, got into the books and records of the debtor on our own pro se motion. Pro se means without an attorney. We went in to examine those records with our own company's CPA, Certified Public Accountant. And I had studied accounting at Harvard and worked with corporate records, and we easily documented a multi-million-dollar bankruptcy fraud that we reported to the trustee who confirmed it. We also found a team of out-of-state lawyers, New York and in California, who worked for a nonprofit. Again, we're out of money. We can't hire an attorney, but they worked for a nonprofit public interest group and easily documented the insurance company, the insurance coverage. Within 2 business days of our pro se filing, here it is. Again, pro se and without an attorney, but supported by the amicus brief of those public interest lawyers, we filed a complaint at the Massachusetts Supreme Judicial Court exposing the insurance coverage. Within 2 business days of our pro se filing, no hearing needed, travelers called for a global settlement. That's to release the debtor any claims against that finishing plant. Thus, on January 6, 1999, travelers settled with my family and one of our former employees for $9 million. And this is where it's going to start getting interesting for you. I'm sorry, but I had to give you the background.
I just want to acknowledge that out of respect for the other witnesses that do need to present, all who have limited their testimony, I just ask that you keep that in mind. We have all of the materials and the council members have reviewed these materials. So you need to start to summarize and the
Yes,
council
thank you.
members will acknowledge.
But at that settlement, we told our settling attorney that we feared that instead of a good faith settlement, we were actually, and she admits this at her deposition testimony.
But
We
Ms.
feared we were-
Ms. Pizzotto,
May I put on my case? It's not much longer.
Can I ask that any
People need to know what happens to people who go into settlements.
Ms. Pizzuto, the council members have asked that the remaining portion of your testimony be pertinent to the matter that we are here for, which is the nomination of Judge Serge Georges.
Yes, he will be sitting on the Supreme Judicial Court. He will be overseeing all of the other judges. He will be overseeing, I think it's on page 1 of my thing, isn't the Supreme
Yes,
Judicial
please summarize. Please summarize your testimony
Court?
with the pertinence of your matter to the nominee's presence here today. You have 1 minute to do so.
He will be overseeing the conduct of the attorneys and the judges in our courts of law and their ethics in lying to juries and then creating false records.
You can't enforce a contract.
Okay, so at our settlement, we said that we thought in good faith settlement, we thought we were actually being set up for a trap in which attorneys who had failed to do the required work and had malpracticed and abandoned us, but were highly placed at the very top echelons of the Massachusetts trial courts, would be able to take it all away. We had been warned that certain attorneys do that, and we knew who their contacts were within the courts. But our trial attorney, our settlement attorney, said at her deposition that she, quote, foolishly, that's the word she used, thought they were, quote, honorable professionals and convinced us otherwise. So we settled. The behavior that ensued in the Massachusetts courts after that settlement makes the prior bankruptcy and insurance frauds look like the work of Boy Scouts. If you would allow me to please let this council know what is going on in the courts, I really think I have a right to address them on
Yes,
that.
Ms. Pizzotto, you have now almost half an hour presented your matter. We are concluding your testimony at this time.
May I just,
And Councilor Devaney
start
has a question
with
for you.
that?
We're going to begin the questions from the council. Councilor Devaney.
Yes, thank you.
Thank you, Lieutenant Governor. Judith, it's been a long time, and I haven't heard from you, and I've lost your address, and I cry listening to you because I was the only one on the council with my colleague, Councilor Chris, when this came up. Is it 21 years? How many years was it before the appeals court was Socorro?
Oh, I think that was
20.
It was a long time.
Okay,
So
well,
much to
whatever it was, and I will never, ever forget. And I have mentioned it to the councilors about Judge Socorro. And I was the only one that voted no, as you remember, that he was elevated to the appeals court. Now, let me just say, I listened to you, now it's my turn, okay?
Yes.
So what happened was, I want people to know, I want the public to know what this is all about. We had a Judge Socorro of the district court that was presented to the council to go to the appeals court. 5 people came in opposition. Unheard of. I've never had that happen in all my 21 years. It was so unbelievable, so egregious that this man would be elevated. There was a young woman who came in. She had 5 children. Her husband was a police officer, and he was on a special detail at a construction site during the day, daylight. And a 50-year-old woman came speeding and ran over him and killed him. And that hearing was a travesty. And she talked about it, and she had a 2-year-old to a 13-year-old at this time. The 2-year-old, and if anyone has a 2-year-old, I've had 4 that were 2-year-olds. How long could you hold that 2-year-old in your arms? He came an hour late, and he walked in and said to the little baby, "Keep him quiet in my court." Now, I'm very investigative. The next day, I called the victim, the police officer's father, and he said to me, "My daughter-in-law found out at the last minute from a police officer that worked with my son, and I couldn't get in there to testify." He said, "But I want to tell you, I was sitting with my 13-year-old granddaughter, and she was going to make a statement. And she said to me, 'Grandpa, it's 3 pages. Is it too long?' And he told me, he said to her, 'No, honey, you read every word. That's your dad.' As she was walking to make the statement, Judge Sikora said, 'Hurry up, get this over with.' She broke down. This is a child, 13, who no longer has a father. Her mother is a widow of 5 children." And he kept interrupting her.
Okay, Counselor.
This is unbelievable.
Counselor.
Do you know what sentence he gave this woman who killed the police officer? 6 months suspension of her license. And he turned to the widow and said, "Do you know what it is to go without your license for 6 months?"
Yeah.
Now I'm not going to talk about all of the
Counselor,
cases.
this is beyond the scope of.
What time is it?
It is, no, it is beyond the scope of the.
Oh, I don't think so.
No, it is. I am presiding.
I know,
and
but
this is beyond the scope of the matter that's before the council today. And in respect to the nominee, Judge Serge Georges, we're going to conclude.
Well, knowing
with this
Judge Georges, I would like to hear this. Her husband had an auto shop next to a chemical company. And whatever was spewing out of that company took the finish off his cars and gave him pancreatic cancer. This man he knew he was dying. He wanted to get a settlement for his wife and his 2 daughters. And Judge Sikora and the district court held it on Halloween and gave instructions to all the jurors to come in Halloween costumes. You can't make this stuff up. And they came as a nun, a priest, a traffic pole. And you know what? They gave out Halloween candy. It was a party. Now, if you're dressed as a clown, can you really attend to what you're hearing? That this man is dying. He's trying to get a settlement, rightfully, for his family. And guess what? I still have it in my drawer in my office. I have a paper that was written by one of the jurors, and it says cast of characters, and it lists every juror, and it has a movie star beside that name. And on the bottom, it says, Judge Sikora wants to be Robert De Niro. If I went into a courthouse, I'm going to ask you, would I be able to go in, come in security dressed as a clown? This was a judge. And my counsel voted him to be this to the appeals court.
Counselor.
I'm not going to tell you all the other cases that were so egregious. There was an
Counselor,
attorney
we need
that came
we need to
and he
conclude.
destroyed his reputation. He reported him to the BBO. It was in the Herald and the Globe. And you know what? The only consolation I had was he will no longer sit in a district court to hurt people.
Okay.
He'll be in appeals court.
Thank you, Counselor.
So much more. I'm being
Thank
cut off.
Thank you, Counselor. And I want to thank the witness, Ms. Picciotto, for presenting today. We are going to take a short break. We will come back to this room at 11:30.
I've been cut off from the most
Okay, it is 11:30, and we are resuming the hearing relative to our nominee, Judge Serge Georges. Welcome back. We have another witness that would like to present that's neither for or against Judge Georges. We then have additional letters that will be read into the record, and anyone else that would like to be heard before we break. We actually will then go into the nominee statement.
We're so far behind at this point, Governor. So a few minutes each.
Yes, we would like the testimony to be pertinent to the matter before us, which is the nomination of Judge Serge Georges to the Massachusetts Supreme Judicial Court. Our next witness that would like to present is Ms. Heather Gordon. And at the request of the council, we request that you present your testimony within 2 to 3 minutes and then allow for questions from the council members. Okay, Ms. Gordon? Please unmute your phone. We're unable to hear you, Ms. Gordon. We're unable to hear you.
Maybe given the technical difficulties, get back to this person and move on to the nominee statement if we can't hear
We
it.
have, what I will do, we did receive a number of letters in support of Judge George's nomination. Ms. Gordon, we are still unable to hear. I would like to acknowledge these mostly colleagues of yours and others observers of your career. The first is Judge Mark Coven, First Justice of the Quincy District Court, Judge Neil Sharing, Associate Justice of the Housing Court, Judge Robert Foster, Associate Justice of the Land Court, Judge Howard Spicer, Associate Justice of the Land Court, Attorney Stisha Emanuel, President of the Massachusetts Black Lawyers Association, the Massachusetts Black Judges Conference, Attorney Roger Bertling, the Director of the Predatory Lending and Consumer Protection Clinic at Harvard Law School, and Attorney Paul DeMarcus, a private practitioner. These letters, in summary, offer enthusiastic support for Judge George's nomination. They praise him for his wonderful temperament, compassion, and empathy for those who come before him. He projects a personal warmth and command over his courtroom and of the cases that come before him. It is clear he takes the time to review cases thoroughly, going right to the heart of the issue and asking penetrating questions of the parties, and that even when he ruled against a client, that attorney would have confidence that he had taken the time to consider all arguments. These letters praise, and these individuals praise his tireless work ethic, his diverse legal experiences, and compliment a judicial approach that is reflective, not reflexive. And these letters have been shared with members of the council, all members of the council, and are submitted on your behalf into this record and hearing today. Relative to opposing witnesses, we did receive one letter, and the author of the letter has asked that we read the letter into the record, which I will do so now. This letter is from Ann M. Stevenson from Salem. Dear members of the council, good afternoon. My name is Ann Stevenson, and I am an attorney who would like to share with you my concern about and opposition to the nomination of the Honorable Serge Georges Jr. to the Massachusetts Supreme Judicial Court. Judge Georges should not be confirmed to the SJC because he lacks the experience and essential skills and qualifications to competently perform the essential jobs duties of the Supreme Judicial Court. One of the essential functions of an SJC is the ability to assess and write complex legal opinions. According to the Massachusetts Court's docketing system, Judge George's practice before the SJC or Appeals Court includes the following, and they are noted: 2009 P-1420 and 1999 J-0588. Judge Georges has only been on the bench a very short amount of time, and during his tenure served only in the Boston Municipal Court, Drug Court, and Traffic Court. Judge Georges has never served in the Superior Court bench or the Appellate bench, and I am not aware of what, if any, significant trial or opinion writing experience he possesses that would qualify him to serve on the SJC. To put into context, I have been an attorney for 3 years, and I have appeared to have more appellate experience with than Judge Georges. I remember recently sitting in law school classes and thinking that the SJC is the most prestigious bench in the state, and so those who sit on it must be extraordinarily talented. Then, as an attorney, I had my cases go up to the appeals court, and 2 were even taken up by the SJC. I remember being in awe of the justices. Even if Judge Georges had significant criminal law experience, Massachusetts already has an SJC bench that is filled with conservative former prosecutors. Not a single justice comes from a public defender background or any experience in juvenile court matters, child welfare, or disability law. Consequently, many of the legal issues that require the most urgent decisions are neglected, while the decisions we do see coming from the SJC are sometimes draconian and entirely out of touch with the practical legal issues facing families. As a clerk intern in the Boston Juvenile Court, I was thrilled when Governor Baker announced his dedication to reforming and overhauling the Department of Children and Families and the child welfare system. In my experience as a court-appointed bar advocate for kids and adults on juvenile courts, 90% of my clients are not white, and all of them have impairments and disabilities. The unfortunate consequence of having no one on the SJC who has juvenile court experience is that the SJC has steadfastly refused to address any issues concerning child requiring assistance, case law, and there are no rules of law and no case law for these cases. The result being that kids are placed in the custody of the Department of Children and Families in unnoticed secret juvenile court hearings without due process and with almost no paper trail and no real right of review. Though Judge Georges is likely a nice guy who commands the respect of his colleagues, it would appear that he is woefully underqualified for the SJC position, which he has been nominated. I would understand picking someone underqualified if they were coming from the juvenile court, but there seems to be no benefit in promoting Judge Georges on the basis of his nice guy status. When Kimberly Budd was nominated as Chief Justice, it was not because she was a nice person. Judge Budd was nominated on the basis of her outstanding achievements as a lawyer, her experience on the bench, and the hard-earned respect and qualifications her colleagues rightly credited her with having in the legal community. I was thrilled with Justice Budd's confirmation, but I cannot in good conscience support putting a young judge with almost no qualifications on the state's highest court. It is at best a missed opportunity, particularly in light of the declining status of our state's most vulnerable families, just trying to find some justice and acknowledgement from the courts during times of crisis. Lastly, I don't claim to have any personal experience appearing before Judge Georges. What I would say is that if lawyers did have an issue with the professional conduct, they would not risk stating those grievances to the Governor's Council, which has really rejected any appointment made by Governor Baker. For these reasons, I would ask that the Council deny confirmation. Signed by this attorney.
Hello?
We are having difficulty with this witness. We will proceed to the next portion of our hearing, which is to receive the statement and presentation from Judge Georges. Please welcome.
Hello?
Thank you for sporting the colors today. We appreciate that as well.
Thank you.
I would like to now turn it over respectfully to Judge Georges.
Thank you all. I know that Governor Baker is not with us, but Governor Baker, Governor, Lieutenant Governor Polito, council members, friends and family, good morning to you all. About 2 weeks ago, on November 13th, I celebrated my 7th judicial anniversary. 7 years ago, I was a lawyer applying to be a judge, and I came before this council hoping for your advice and consent to be a judge of the Boston Municipal Court. one of the oldest courts in our great nation, dating all the way back to 1822. What I didn't know at the time was that I would be assigned to the Dorchester division of the BMC, a courthouse that is only a few miles from where I grew up on Hancock Street in Kane Square. Presiding in the courthouse, serving the neighborhood that I grew up in, is an honor that I can't adequately describe. All I can tell you is that from my seat, it was really hard to imagine. And here I am again today before you all, hoping again for your advice and consent to join the highest court in our Commonwealth, the oldest Supreme Court in our great country, the Supreme Judicial Court of Massachusetts, whose roots date back all the way to 1692. Imagine that. In between my appearances before you, these last few years have been quite something. Joining the Boston Municipal Court and sitting in the Dorchester Division has not only been a tremendous honor, it's changed my life. There have been pressures, of course. We make many decisions every day, each of which involves the rights and liberties of my fellow citizens. Experiencing people's real stresses and trauma, their deepest, darkest fears, seeing the very worst amongst us, and equally seeing the very best. In the words of a dear friend of mine, human beings can be rather awesome if we let them. But every single day I have felt humbled, not only by the responsibilities of it all, but by the extraordinary people with whom I have shared each day. As the judge, we may sit in the comfy chairs and we may wear the robes that signify that perhaps we might have the last word. But it doesn't take a single day in that environment to be reminded that you are just part of a team. Just as no quarterback can function without a strong offensive line, no judge can function in a busy court without a huge team, all working together in the name of justice. Today, and a few weeks ago, Governor Baker mentioned at my introductory press conference and again today in his remarks about how rare a nomination to the Supreme Judicial Court is from the community court departments. But it shouldn't be, because from the probation officers and the prosecutors, to the clerks and the court officers, the police officers and the public defenders, the translators, the court clinicians and facility staffs, we are an incredible ecosystem in which we all are entirely dependent on the dedication, effort, and public spirit of each other. So one of the things about my nomination that makes me the most proud is that I have been nominated from the community court department and the courts of limited jurisdiction. So to all of you out there, all of the wonderful people that comprise the district court, the juvenile court, the probate and family court, the housing court, the land court, and my beloved Boston Municipal Court, I am so very honored to be sitting here as Governor Baker's nominee to the Supreme Judicial Court. Not because it's me, but because it's us. Ours is a world in which colleagues become friends, and friends become family. And I feel blessed to describe and thank my family at the Boston Municipal Court, represented here today by my friend, my mentor, and my colleague, Judge Kenneth Fiandaca. And my Dorchester Division family, represented here today by my friend, Presiding Judge James W. Coffey. But I also want to thank members of our judicial team who couldn't be here today, but I know are here with me in spirit. Judge Thomas Kaplanis, Judge Lisa Ann Grant, and Judge Jonathan Tynes. People I have proudly worked alongside and respected, and whose company and counsel I have treasured, and whose place in my heart remains forever, even when I vote to reverse you. FJ, Lise, Tommy, and JT, together along with the clerks, probation officers, court officers, and staff of the Dorchester Division, we had our fingers in the dirt. We shared complex cases and issues, heard heartbreaking human stories, and experienced some life-affirming episodes. And we also shared a whole lot of laughs in that library. I thank you for your part in my journey, and I want to say to you and the rest of the Dorchester Division family, whom I suspect is watching along in the 6th session, it's been my honor to be part of you. As the son of Haitian immigrants and as someone who not so long ago was just a young black boy from St. Kevin's Parish in Dorchester, I'm feeling extraordinary pride in sitting here right now. But I also feel a deep sense of responsibility. Responsibility to my parents, whose hard work, honesty, and selflessness paved my way and led my way. And responsibility to every person out there who hasn't the good fortune or the support or the opportunity that has allowed me to make this journey. The rest of us of modest beginnings, who remember the days when we didn't always buy whole pizzas, where we'd play outside until we got hungry, and we'd collect our pocket change to buy a slice, just a slice. And if we were lucky, maybe we'd share a single can of soda. And none of us should ever need reminding that there are children out there right now, from Pittsfield to Boston, from Lowell to Webster, from North Adams to New Bedford, who struggle even to afford that slice. I hope that by seeing me here today, or hearing my story, that you are reminded that your dreams deserve to come true too. Which means that I don't only stand here representing Michelle, Olivia, and Samantha, however much I love you and adore you and thank you. And I don't only stand here representing the great institution of Boston College or Boston College High School or Suffolk University Law School, where I fell in love with this profession. And I don't only represent my colleagues, both in practice and within the Massachusetts trial court. I don't only represent the young people of color across our Commonwealth, or the immigrant families, or those of little means, and those for whom the future feels anything other than bright right now. I don't only represent the great people of Haiti, as talented, resilient, optimistic, and generous a people as there are on this earth, and I know this for a fact, because those are the words that describe perfectly my mom and my dad. The truth is, I stand here representing you all, along with my friends that I've met along the way and those that sadly I may never get a chance to say hello to again. Because if there is one thing I have learned to this point in my life, is that there is no us and them. There is only us. And we all walk together. Something so obvious that sometimes we are blinded to it. But fortunately, we sit within a Commonwealth whose highest court's history is one of courage, leadership, inclusivity, and empathy. That is crystal clear. Our Declaration of Rights provided the foundation for the Constitution of these United States. Oliver Wendell Holmes sat here before embarking on the longest and most glorious tenure on the United States Supreme Court. And the SJC is the author of the Goodrich decision that led the way to victory of love. So the prospect of following in those giant footsteps is humbling indeed, but it's also inspiring. And given your advice and consent, I will do everything possible to represent every single person in this Commonwealth every day, and to remain grateful for every single second during which I have the opportunity to do so every day. I close again by thanking Governor Baker and Lieutenant Governor Polito for nominating me. I'm humbled and I'm honored by your confidence in me. And if confirmed, I will do everything in my power to be worthy of your trust. I thank Counselor Jubinville, my host counselor, and the other members of this great council for yet another opportunity to be here. I thank you for your time, and I look forward to your questions.
Let me just thank you, Judge Georges. I do want to acknowledge that Ms. Gordon is going to submit her testimony in writing. I would like to, before going to Councilor Devaney to question, is there anyone else that would like to be heard either in favor or opposed to our nominee? Seeing none, that concludes the witness portion of the hearing today. And thank you for your statement and the references to your court colleagues as your family, and that it is us. And as we come together to this room, those words are particularly important to hear. I'd like to now begin with Counselor Devaney.
Welcome.
Thank you, Counselor.
Always nice to see a smiling face. And, you know, I think of so many people who fear going to court and looking up at that judge's face. And that's what I love about you. You know, I don't think anyone would fear going before you. I do want to make a couple of remarks, if you'll allow me, before I question you. For the public, this is a governor's council hearing. And the protocol is presided by the district counselor of the nominee. And I want to say, been here 21 years, no governor's councilor presiding ever cut off a colleague on the council from speaking. And I was cut off by the lieutenant governor today, who chose to chair this hearing. And I want to publicly say it's disrespectful. Now, the other thing I want to say is I want to thank all the people in this State House who are cleaning every day. I see them, I'm here every day, and they're making it safe for us to have you come in person and for us to be in person to have these Governor's Council hearings. And I just want to say, and I say it respectfully, to my counselors who choose to come in Zoom. I attend every hearing here. It's safe. And I just want to give a message to Councilor Hurley. I don't know whether she's still in Florida, but you know what? Safer here than traveling. So I just want to give that message, and I want to thank everyone for keeping us safe here and for allowing us to have you come in person. I didn't want to see you on Zoom. I wanted to see you in person. So having said that, congratulations.
Thank you. I'm glad to be here.
No, and thank you again for meeting with me at the diner. And you're on the Hall of Fame for the Belgian waffle, now twice. And I want to thank the other nominees for meeting with me. It's very important for me to get to know the whole person. And I really got to know you 7 years ago. So I'm very, I don't have a poker face. I'm very happy with this appointment. Now, I am going to ask you, well, first of all, I always ask about the journey that you had here. Now, you applied to the appeals. Okay, now, the appeals court. Now, did you go before the JNC?
I did.
You did. And how many people were there?
I believe there were 10 on my panel.
Okay.
It might be, please don't quote me on it. It might be a little bit
Maybe
less.
10 or 12. But I say this publicly, not for you, but for the public. The governor appoints the awesome responsibility to 21 lawyers to attend that hearing and hear the nominee ask the questions and then vote to make a recommendation for the governor, for the governor's council to appoint that person. 10 is egregious. And this is not done before, and I've said it over and over, but nothing is ever done. So having said that, okay, so I know what the story was. It was only a couple of days later, was it, that the SJC came up? So tell me about the sequence, how that happened, did you notify them about the appeals that you were not interested? Because on your JNC questionnaire, it says pending. So just tell me how you undid that.
To be honest, I didn't undo anything. I think they were two very different tracks. I had applied to the appeals court, and at the time, there wasn't an application open for the SJC. No sooner that I had submitted the application to the appeals court that I heard that the application period was going to be open again till September 11th. And I think you heard one of my witnesses this morning, Howard Cooper, say he reached out to encourage me to apply. And I did apply, and my understanding was that they were just two separate tracks.
Right. Well, I have to say that your wife is your biggest cheerleader, you know, that to go forward. But I'm so glad that you did, really. And I always say God works in mysterious ways. Now, I'm going to ask you, I really know you because we go back, you know, in the past when I first voted for you. And I'm going to ask you a personal question. What does it mean to you in your heritage as a Haitian American to be appointed to the highest court in Massachusetts?
I can't say that it means everything, but I can tell you that it's pretty close. You know, of the things that you kind of have personally, it's the you know, however old I am now, 50 years old, and every day that I'm alive, I hope to make my parents proud. But I also know the journey of immigrants and specifically of Haitian immigrants. And I know some of the challenges, both the natural disaster challenges and the economic challenges. And I just know the spirit and the support and the encouragement of the Haitian people and the Haitian culture. And I feel it. And when I hear from other Haitians of the Haitian culture, sometimes it's hard when you're looking out of your own eyes to feel what it feels for other people to see you do well. And so when you hear from other people of Haitian descent to say how proud they are that a fellow Haitian may potentially sit on the oldest Supreme Court in the United States, that's the kind of thing that just, I know it seemingly is the word, but it humbles you that people are so happy for you and so happy for our native country.
Well, I know when we met and you said, imagine Oliver Wendell Holmes. I mean, that's so amazing, you know, and well deserving. And I'm going to share with you something I have never said publicly, never shared it with friends or my colleagues. I don't even compare myself to your position and now going to the highest court in Massachusetts. But this is my little private story. I am the first Italian American woman elected on the Governor's Council since 1780, when it was established by the Massachusetts Constitution. So I've never said it publicly. I've never said it to even friends, but I'm sharing it with you as a first generation American. So it is special. It is special because we know what my family went through, discrimination, prejudice, and I did, and you did, your family did, and we got through it. And look at you going to the highest court. And you have your parents to witness it. What could be better than that?
There's not much.
No, but I do want to talk to you about questions that I've asked in fairness to the other nominees, things that I'm very concerned about. Well, you know, I said to your witness about, I'm concerned about child abuse through this pandemic. And you can talk about that. But the one thing that I am learning, and I'm desperately learning, about foreclosures, these are fraudulent. And in all due respect, the SJC is really not educated on foreclosures, what is happening. We have judges that are not asking who the mortgagee is. And it's some entity in New York. And they're taking the houses away from good people who are paying their mortgages, and they think they're paying it to a bank. And as I said to one of your witnesses, what's going to happen is the Commonwealth is going to go bankrupt because all these unfortunate people who've lost their homes are going to be homeless. Some of them already are. Some of them already testified. So I'm going to ask you about Massachusetts being called a title theory state. What does that mean to you?
Well, the homeowner has the beneficial interest, but it's subject to the mortgage of the bank. And so there is a chance that if you default on your underlying mortgage, that the mortgage may be foreclosed upon and you might lose legal title.
Okay. Now, why do you believe that this is so important for Massachusetts
Believe
to
what?
be, to be a title theory state?
Well, I don't know if I said it was so important. It's what we have. It's the system that we have. And so the system of foreclosures and for banks to go in on the foreclosure is a matter of statute.
Okay. So, all right. I'm trying to learn about the Uniform Commercial Code. Are you familiar with that?
I am.
Okay. Do you think it's overly stringent?
I don't know that I think it's overly stringent. I am always careful about what my role in my lane is. The legislature has enacted the Uniform Commercial Code to give some uniformity to commercial entities and folks that work with commercial entities to get a uniform series of laws that everybody can have some reasonable idea of what the law requires. That is a matter of legislative enactment. Now, if there are issues or disputes that come up where somebody's alleging violations of that might wind their way through court, then that's what gets adjudicated, and ultimately the judges might have to make some decisions about whether or not a party has proved their case or hasn't proved their case.
So do you think it's important that the Mass Court applies this Uniform Commercial Code consistently, including mortgage notes?
I think that when the legislature has spoken and told us this is the law of the land, that judges have to apply that in the way that they know how. And so when you talk about judicial discretion, the statute says what the statute says. So the application of that is to be meted out by the trial judges. If the parties think the trial judges have made a mistake, the parties can avail themselves to an appeal. And the system works the way it's designed. That's why we have reviewing courts of error correction at the appeals court. And ultimately, if there's further appellate review, that's granted to the SJC.
Do you feel that people who do not have an attorney to represent them are being treated fairly?
In my personal experience, I find that judges are incredibly sensitive to self-represented litigants, particularly on the civil side where we know there's no constitutional guarantee to counsel. But at the same time, out of fairness to the lawyers, we tell people and we make sure that self-represented litigants know that we have to hold them by and large to the same standard as a practicing attorney. So I do think that there is sensitivity to it, and I think that judges do a very good job, at least as far as I could say, again, anecdotally in my experience, that it's something that we are incredibly sensitive to make sure that people understand what's happening and trying to commend to their attention maybe free legal services if they don't.
What about the judges who don't require information to know who the mortgagee is? And so these are, that's why they're fraudulent, because, someone comes in there without a lawyer and they have been paying their mortgage, they've been a good citizen, and they think they've been paying it to the bank, but it's not going to the bank. It's going to this entity that they don't even know.
Mm-hmm. I'm always careful to make sure that I don't use legal terms colloquially. When people say that things are fraudulent, that is a matter that's actually have to be proven in court. So when somebody says either I don't know who is the plaintiff in the case, there are devices under our rules of procedure in terms of motions to dismiss to say, I don't think that you have standing. I don't think you have the ability to sue me for this. And that is a matter of raising that issue, litigating that issue, and then having the trial judge make a decision on whether or not, again, the moving party has made their case. All of those things, I don't say them in conclusory fashion because it is a product of the litigation process. And it's important for me to respect that because I was a lawyer and now I'm a judge. So I can't jump to that final conclusion. It's a matter of the litigation process.
Okay, let's talk about how there's two documents signed by a homeowner to get a mortgage, okay? The mortgage contract and the mortgage note. Now, what is the function in relation to each other in Massachusetts, those two?
Say that
Can you
again?
explain that? There are two documents that a homeowner has to sign to get a mortgage, the contract and the mortgage note.
Okay.
How does that function? How do those two things function in relation to each other in Massachusetts?
Well, the mortgage would give the right title and interest to the mortgage holder, the bank. But what's securing the payments on that mortgage is the note. That's the contract to make the payments according to whatever the terms are of the mortgage contract. So if you default on the note, that is what gives the mortgage holder the right, typically, under the mortgage to go in and foreclose.
Okay, now, I brought up some factual cases, okay, to the other nominees that are really upsetting to me. And that's why I can't urge enough that the SJC get more involved, form a committee so that they can get up to speed on these fraudulent foreclosures. I had mentioned, and we had actually had the man come and testify on Zoom, a blind man, okay, who was paying his mortgage all the time. His mother and father, one had Alzheimer's, the other had cancer. He had to take care of them. He couldn't afford a lawyer representing himself. And when he went before the judge, they demanded that he sign this document. This man could not see. He signed something. And he was threatened if he didn't, that he would have to go to court in the afternoon. The judge was not truthful. There was no afternoon court. So he's homeless. He's homeless. And there's so many that fit that situation. And yet the judges are not asking who the mortgagee is. These people in good faith are paying their mortgage, and all of a sudden their house is taken away from them. And you know, and I think of that young woman in her 20s. She came to court, dressed very professionally. She had all her documents in order. They said that she was better than any lawyer representing herself. And the judge said to her, "What education have you had?" That's not what the judge should be saying. And then I know of cases, people out in the hallway in tears, single mother in tears, because a lawyer is bullying her in the hallway. So I'm just saying, I want to bring this out to you because on the municipal court, I know you've had evictions, and I think that's an asset for you to go to the Supreme Judicial Court, but you haven't had foreclosures, have you?
In my private practice, we did.
But I know, and I'm very happy for that, and that's why I support everything you're doing, because you understand it, because you have represented people. But as a judge, you know, you haven't had any instances in the municipal court relating to your former attorney experience. I want to know what you will do on the SJC to get everyone up to speed to, you know, on this situation. They're fraudulent. They're egregious. I mean, it's happening. And these are people representing themselves. So what would you plan to do as a member of the Supreme Judicial Court?
Councilor Devaney, over the time that we have spent together, I have told you that I have respected that you call it like you see it. And you have equally told me the same thing. I'm a judge. I make decisions on what's presented to me. I know that you have more facts about some of the things that you're talking about that I do. And it wouldn't be fair of me to say one way or another about something that I know nothing about, that I haven't seen. And I know what you're saying about what you feel another judge did, but that wouldn't be fair for me to do that. So I can tell you that just as if it's not just about self-represented litigants and foreclosures, it's a much larger issue. It's self-represented litigants, period, and whether or not they're getting a fair shake when they're coming in to litigate their cases, and that judges make sure that it's fair, that they understand what they're doing, what procedurally is happening, so that it is fair. So as judges, we have to make sure that that's the case, because ultimately, whatever judgment may enter against somebody or for somebody, we have to make sure it's fair. So all of the things that you're talking about, judges try to do the best that they can every day to make sure that the system is fair. And I stand by those judges, and I stand by our judges. And I know you have instances where you think that didn't happen, and I respect that.
Well, I have a judge in mind, and I think that, it should be investigated what she's doing, because it's just not one case. It's this blind person. It's this young woman. It's constantly. And I think, unfortunately, I don't think we look at the land court and the housing court with the attention that we give other courts. And I think it's time the SJC looked at it to see how these judges are treating these people representing themselves. It just seems to me that, there's such an injustice. Where does this blind man go now? Where does he go? He's already been, he signed away his life. And yet, how outrageous. I mean, it wasn't in Braille, it wasn't anything, or to treat that young woman. But that's what I'm hearing. And the biggest thing is foreclosures, and it's going to be for the next decade and more that this is going to be happening, especially in this pandemic. People are out of work and they're losing their homes. So I can't emphasize how important it is for you and for the SJC members to have form this committee, a task force, who can look into it, who can report to you people. And it's an education for you people too. And I've heard of recent decisions that don't please me that has been happening. And so it's continuing. So, I'm saying that in behalf of all of these people who are representing themselves. It could be me. I'm a widow, have a house, have a mortgage. And, I just don't understand. There's no action from the SJC against these illegal, fraudulent foreclosures. And they have to be supporting these people. No one should be homeless when they're doing their best and paying their mortgage and everything, because judges, not all of them, but judges are not asking who's the mortgagee. So it's some invisible person out there that's taking the homes away from people. And these are disabled people. These are people of color. This is the majority of them. The majority, that's who are the victims. And so, I can't be more emphatic about it. And I'm just asking that you support to have that task force, because that'll be the greatest thing to show these victims that you're there trying to help them. And maybe we can reverse some of these decisions for these people. I know, and I talk with you a long time, and I know you well. And I've always said, I say it over again, I'm redundant, I look for compassion and empathy. I don't know anyone that has more compassion or empathy than you. I mean, we talked about things, tears came to our eyes. You're like me, and you're emotional, and that's what you need. And I love your demeanor and your temperament, but we've got to get the SJC on board to be proactive on this. Look into these courts, see what judges are being unfair to these people, see how we can help these people who have foreclosures. And, there's people out there fighting for them, and we never hear of them. And I've given 2 names to Judge Budd so that she will have them on that task force. I think it would be, I think it would be something to say, yeah, they're doing something about it. I just don't want to say this and have it go out in the air. I want action from the SJC for all of these people suffering and for all those good people who are representing them. God bless them, you know? So, you know, I'm learning. There's no way I can know all of it, but the things I'm hearing, you could cry with these people. Homeless, I can't even imagine. So, you know, so I'm hoping that you will do that. The other thing is, I want to clarify, you are appointed to replace Justice Link. Justice Budd was replacing Justice, God bless his soul, Justice Gantz, and Judge Winford was. So I just wanted to correct that because, you know, she is replacing the Chief Justice. And so that's hers. So I just wanted to say Justice Link. And I do want to say, put a plug in for Justice Link. I've heard good things about her regarding this whole situation with foreclosures. Now, from what I'm looking at, Justice Gantz was involved in it. God rest his soul, he didn't get to do the things that he wanted to do with it. So that's why I'm saying the ball's in your court, and you people have to act on it and look at this, because no one is concerned about foreclosures unless it happens to you. And that's what the sad thing about this whole matter is, you know? And so, you know, there's so many laws and rules, you know, but still, how do you tell someone who's representing themselves and they're being harassed? I mean, these people come in, they can't take any instrument, they can't take their cell phone or anything, but the opposition is there with all kinds of things and attorneys. It's not fair. So, you know, and I know your fairness, so I'm putting all my eggs in one basket, and I'm going to you to ask you, look at the foreclosures. Let's help these people. There are people out in the trenches that have been representing them for years. And one person I heard from is a lawyer, and she got involved in this fraudulent foreclosure. So you know what that says? It can happen to anyone. And you know how long she's been fighting for justice for herself? 10 years. So, you know, I might only have the tip of the iceberg on this whole situation, but I'm sticking with it. And I'm going to be watching the SGC. I'm going to be watching to see they form that task force. So I'm very happy you're there. And I hope I didn't come on too strong, because I love you. I'm so happy. And, you know, and to meet again and for you to take the time in all this crazy pandemic. I brought you to a safe place. I mean, I would never, you know, expose you. You know, as I said, we're living in dangerous times. As you know, I have a sister that died in a nursing home of a coronavirus, and my other sister is struggling in assisted living. So there's no one that's more careful about that. And that's why I urge my counselors, come in person, okay? And I want to see that you people are going to, your first action is going to be, let's look at the foreclosures and form that task committee. Okay.
Thank you.
All right. I don't mean to lecture, but you know, I really, my hat goes out to them, because I can't even imagine being in that situation. And I could be, you know, so, but thank you for applying. I'm over the moon in this appointment, and I'm so pleased, and I'm sure you'll be on board right away too, you know?
Well, I appreciate the sincerity to which you take your role as the governor's counsel, and I appreciate the warmth that you've shown me.
No, you're great. I mean, and like I say, people fear going into the court. And what I love about you, you always have a smile. You're always engaging, and that means a lot. And you know, some of the older judges maybe could take a lesson from you too. So thank you so much.
Thank you.
Good luck.
Thank you.
Yes, thank you, counsel. I just want to acknowledge that Justice Budd was named from the court to become chief, and that Justice Wendland was nominated and confirmed by this council for Justice Lang's seat. And I also want to acknowledge that this convening was done with a ton of work to make sure that it was compliant with COVID safety protocols. This is a large room with capacity limits. There was distance between us, face covers required if you are not speaking, hand sanitizer for everyone so that you're safe and comfortable in this setting. We have also, through the technological means available, allowed for remote participation by council members because of underlying medical conditions for a counselor as well as individual circumstances of another, so that they can fully participate in this very important proceeding. We've also allowed for witnesses who are unable or do not feel comfortable being in this setting to be able to participate through WebEx to deliver their testimony in, live or by written testimony as well. And we have the ability for live streaming. So there is full awareness in the Commonwealth of Massachusetts that this matter is occurring and people can listen and hear it individually. The next two counselors are participating by WebEx as is permitted as part of this proceeding. And we'd now like Councilor Duff to question the nominee.
Thank you, Governor. Can you hear me?
We can.
Yes. And on that note of what you just said, Governor, I would like to commend you, your staff, as well as the technology staff at the State House for making this available. I myself, my spouse, it would be at high risk of this. And my 92-year-old mother, who I also am a primary caretaker of, is at high risk. And so I deeply and greatly appreciate the embracing of this wonderful technology that we have, and how terrifically the governor's office and staff have enabled us to reach beyond what we typically have. And to our constituents out in YouTube land watching right now, I've had many people say that they've really enjoyed being able to see the hearings live. So I commend you on that. It's a great use of technology, and it is what technology is for, especially as we are in the beginning of a very serious spike in this worldwide pandemic. That said, let's get to the judge. Judge Georges, this question is very specifically for you because of your background. I'd like you to share with us your opinion. Do you feel we should continue on the path of creating specialty courts? And what do you see as the pros and cons of these courts?
I am a believer in the specialty sessions I've seen, and I'm certainly proud of the fact that the Dorchester Recovery Court, which started as the Dorchester Drug Court, was the first drug court in the Commonwealth of Massachusetts, started in 1996. I do think for the right participants, we can get better results than on the regular probationary docket. I am also a believer in making sure that we do it right. It needs to be properly staffed with the clinician, with the dedicated judge, dedicated probation officer, defense lawyer, and prosecutor, because all of those component parts increase the efficacy and the efficiency in the results.
Thank you. And you do have great experience in this drug court, and that's one of the reasons I think that you are uniquely positioned to answer that question. I'm going to now ask you two questions that some of my more conservative constituents are very interested in. And as I tell people, I don't just represent Democrats, I represent everybody in my district. And one of those questions that they've posed is, and they've asked me to ask is, do you feel that hate crimes or hate speech is protected by the First Amendment?
Well, the First Amendment, we know, protects some things that perhaps people are not necessarily happy to hear.
Exactly.
But not all speech is protected speech. We certainly know that fighting words are not protected. And so it's going to be a fact-specific kind of consideration as to whether or not it's extended to First Amendment protection or whether or not it's accepted under not only the United States Supreme Court jurisprudence, but also Massachusetts Supreme Judicial Court jurisprudence. So you really have to drill into the kind of the kind of words that are being used and the context in which it's being used.
Thank you. In my district, which tends to be one of the more conservative districts in the state, there are many people who are gun owners, and they are curious and there are also many moms and dads of children, and we've seen horrific crimes in schools and mental health issues with people who get guns. We're fortunate in Massachusetts that we have one of the more stringent background check rules and things like that that prevent some of these horrific crimes. But do you feel in this is an opinion and answer it as you feel comfortable, because I don't want to be trapping you into something here. But do gun owners' rights trump the rights of the general public to live in an atmosphere of assumed safety?
I don't think that they're mutually exclusive. I certainly think that the Supreme Court in the Heller decision has made it very clear that there's a Second Amendment right to the right to bear arms.
Yep.
But when you look at some of the legislative enactments, not only with the licensing authority in applying for a license to carry, but also in some of the laws that have been passed by the Baker administration about when there are immediate threats, that there can be immediate recourse in the court system. We know that when folks get abuse prevention orders or harassment prevention orders, there is also an opportunity for the judge presiding over that to make a determination as to whether or not that party, that defendant, ought to submit all of their guns to the local police. So they can mutually coexist. I know that when you talk about unlawful possession of guns, that there's not a heck of a whole lot that the laws can do to keep people from doing that unlawfully. But when it comes to protecting the safety of the general public in the context of their constitutional right to bear arms, they both can coexist.
Thank you. Can you right now, protections have been in place for decades that are now in play with the new U.S. Supreme Court. Roe is one of them. LGBTQI rights are some of them. Civil rights, voting rights. They're all in play. Massachusetts is by far and wide, I believe, to be one of the best places in the whole United States to live because we are protected. How do we stay that way?
How do we stay that way in terms of protecting the rights of the citizens of the Commonwealth of Massachusetts?
Correct. While we have a court in D.C. that has been some members. It's been quite clear that their intention is, and they've already actively started overturning some of these rights, like voter protection, women's rights, civil rights, LGBTQI rights. What can we do in Massachusetts to make sure that our folks are protected and we maintain our rights, all these communities, while simultaneously they're being overturned on a federal level?
Well, Councilor Duff, I certainly think that has two parts to it. One is the legislative part, which is obviously an Article 30 issue and a separation of powers. And the Massachusetts legislature, along with the executive branch, will make their determinations about kind of the rights that we know that the citizens of the Commonwealth of Massachusetts have long had and hope to continue to have. The constitutional rights that we talk under the Massachusetts Declaration of Rights, I think our SJC, one of the things, as I mentioned in my comments, that I'm most proud of is the fact that there is a long history of the Massachusetts Supreme Judicial Court of looking at our Declaration of Rights and saying there may be some instances where Massachusetts citizens are afforded more rights under our Declaration of Rights than under the federal Constitution. So, we judges get judges don't create the law, we get what we get to interpret it. So my view is that we will continue to do what we've always done. And if a matter comes before the court that bears on fundamental constitutional rights or the construction of statutory rights, that the SJC, as it winds its way up, will do what they always do, consider the arguments and make the best decisions that they can.
Thank you. And you touched upon one of the other things I wanted to mention, particularly in reference to what Councilor Devaney was speaking of earlier with some of the mortgage issues that the Commonwealth and in the country will be facing. I, as a realtor, deal with these on a regular basis, and you and I spoke in quite a bit of detail and depth for quite a long time about some of these issues. But I do think it needs to be pointed out, as you just did, that some of this falls squarely on the shoulders and in the hands of the legislature. It is truly up to them to make some of these determinations. And as you said, if the legislature is willing to bail out state banks, then they do need to hold them accountable. If the federal government is willing to bail out banks, then we do need to hold them accountable. And there's a whole lot of other parts and moving parts to mortgages in how people obtain them and who, should they have to take a first-time home buyer class, because so many of these people wouldn't be in these pickles if they had, albeit some of them would be anyway. But I do commend you for mentioning the legislature, because I do think that's part of the law that people forget about, is they are another branch of government, and they do have great control over some of this, perhaps more than the courts do in that reference. And also, I've had quite a few discussions already with Justice Budd, and she is well aware of this issue, and she is actively working on putting together a panel and a commission, so to speak, to address these issues. And I'm sure with your background, with some real estate and land court, which we don't always see either, you will be of great help and service to her. So moving along, what are your thoughts? And again, I'm just asked the question. What are your thoughts on religious protections or exemptions versus LGBTQI rights?
Counsel, I'm not really clear on what the question is.
The question is, right now, gay, lesbian, transgender people in this state are afforded rights. Do religious organizations, does being a religious organization entitle you to not recognize these people's civil rights?
Well, I don't mean to not want to answer your question. My concern always is if I were to get this council's advice and consent, it may be a matter that might appear at some point before the Supreme Judicial Court. Mm-hmm. So because of that, I don't think that it would be fair or proper for me to comment on that. And again, I don't mean to not be responsive to you. I just want to be careful of the canons of ethics, canons of judicial ethics, that I don't violate any of that.
Thank you. Well, you've just wiped out 5 pages of questions, but no, I'm teasing you. Fair enough. And I think you are probably spot on about that, or you may be. How do you think your experience as a solo practitioner will inform your judgment from the bench? I mean, I know you've worked in big firms. I know you've already sat on the bench. I know you've done a lot of things, but you have been in solo practice. And
I have.
That, I think, is matters quite a bit. Does it inform you? Will it inform you? Can you share some of your thoughts on that?
I do, and I think there's one in particular. When folks have small and solo practices, there's a heck of a whole lot of different roles that lawyers have to take on. They take on accounting roles, they take on filing roles, they take on administrative roles. And sometimes, they have to be in multiple places at once. Why I'm mentioning that to you is because one of the things about the Supreme Judicial Court is obviously the cases that deal with Board of Bar Overseer issues. And so sometimes there may be some sensitivity to the fact that when you know the pressures of the folks that are trying to run small and solo shops, some of the potential allegations of attorney malpractice or things that perhaps attorneys could have done a little bit differently, it all helps to understand and bring an understanding that perhaps somebody else doesn't have about those kinds of pressures. The rules are what they are. The ethical rules are what they are. But whenever it comes down to the interpretation of it, it helps when you can say, I understand perhaps what might have happened in this situation when, you're a small practitioner or you're a solo practitioner or a small practice. You can better understand as opposed to perhaps coming from an AmLaw 100 or 200 firm where you had somebody to do everything. Every little piece of what we do every day, there's somebody responsible to do it and you don't have to do it. I think that's important that's an important experiential thing to bring.
Thank you. There's been a lot spoken today and mentioned about your sense of empathy. How's the role of empathy played in how you have presided so far?
In the Boston Municipal Court, the community courts, or other courts of limited jurisdiction, somebody mentioned how if you view the trial court as a pyramid structure, with the Supreme Judicial Court at the top of that pyramid, far and away, the majority of the touches that the Massachusetts citizens have with the trial court is with the community courts and the courts of limited jurisdiction. Do you have to be able to tell the difference with a lot of the different things that sometimes people don't have, that perhaps you did? And being able to empathize and say, perhaps you might say, I would not have done a particular thing because my parents told me not to do it, or I had teachers in schooling in a village that kept me on the straight and narrow. It's important to understand the difference. If I could just focus specifically on the criminal side of the community courts, it's important to know the difference between a criminal and someone who violated a criminal statute. For all of us, the district attorneys, the defense lawyers, and the judges. And that involves a heck of a whole lot of empathy to the things that people don't have. Holding people accountable, giving them an opportunity to earn dismissals and redemption, but still having an understanding that there's a whole lot that a lot of people don't have that sometimes go into why they do what they do.
Thank you. Where does this empathy you have come from?
Part of it is baked in. I think you heard that Attorney Krasnu, and those of us that are from, the neighborhoods, whatever, that may be, it's not to say that you're raised disadvantagedly. It is to say that perhaps you don't have some things that other people do. And sometimes that creates a certain sensitivity in you that, we're all trying to get by. We're all carrying something, so I think that partly is how I grew up. And the other part is, to be quite honest with you, how God made me.
Yeah, I agree with that. I say a lot of times you don't know what someone else is carrying, and you may not think they are, but in my life experience, most people are. I personally feel this is one of the reasons a judge of your caliber and experience in life and work belongs on the SJC. I think you are, we've had fabulous people come before us, but I do think that you have a uniqueness to you in this part of yourself that is consistently mentioned by everybody who knows you or has interacted with you. What do you see as an immediate issue before the SJC?
Well, we have the response to the access to the courts with the pandemic, the safety of all of the stakeholders, whether it's the lawyers or the court staff, and still providing the access that people should expect of the courts in a meaningful way. You mentioned some of the things that Attorney um, actually, Councilor Devaney and you both mentioned about some of the impending issues that are going to come with the foreclosures and the evictions. All of those things are going to become issues down the line very clearly that are issues now that may get a little bit bigger. I've spent a lot of time with some very talented people under the leadership of Chief Justice Fabricant and Commissioner Pam Wood and the other members of the Jury Management Committee, trying to figure out a safe way and a meaningful way for jury trials to resume in the Commonwealth of Massachusetts. All of these things are in, and there are incredibly hardworking members of that committee. And again, when you're in a novel pandemic that no one's ever seen before, trying to make sense of how we give what we're supposed to give in the court system in a safe way, in a meaningful way, all of these things are going to come to a head fairly soon.
Mm-hmm. In some ways, it's an opportunity I see as well for us to take some of the lessons of the pandemic where we've turned to technology and integrate perhaps on a more formal basis and a regular basis into our court system to be as efficient as we can be. You're a young man. I know Councilor Devaney would like you to serve until you're 80, but I think 70 is probably a good. I think most people feel if they've worked a long, hard life, they want to enjoy a little bit of it. So the last question for you is, having answered that question, what do you think will be some of the issues or the biggest issue in 5 years at the SJC?
I honestly think that one of the things that we might see are perhaps collateral attacks on pleas. The pandemic in not being able to perhaps relatively soon get a jury trial, that I could see somebody maybe thinking that I just want to get out, maybe take a plea, and maybe feeling as if I had no other option. All of those things may be things that might come down the line as a result of all of these things. It's an incredibly trying time right now, and I'm incredibly proud of the different members of the trial court and how we're doing what we're doing and doing the best that we can. But I could see somebody, it's always going to be easy to say, oh, you could have done something differently, done something better. So I can see that.
Okay. Well, hindsight is 2020, as they say.
It is.
But I concur. I commend all of our public servants in the courts for working as they do. And I thank you and commend you for stepping up yet once again to public service. It is an ominous responsibility, and it's not something that I know you do not take it lightly. And you could probably be a very, very wealthy man, especially since you're such a young man. If you had stayed in private practice, frankly, and the great sacrifice, not just economically, but I think to your family and to your psyche, frankly, for stepping up to be a judge is something that I don't think is appreciated enough many times by the public, because for some reason, a human nature, we tend to focus on the bad instead of the good. And if somebody makes a mistake, we're quick to point that out instead of, the attaboy and pat on the back when someone does well. And I try, I'm not perfect, that's for sure. But to commend people for their hard work and diligence. And I think the entire court system right now, albeit not perfect, is really working in trying to be as flexible and enabling as they can be. So with that, thank you very much, Judge. I have no further questions.
Thank you, Councilor Duff.
My pleasure.
Okay, thank you, Councilor Duff. I believe we're going to take a lunch break at this time, and we will resume in this room beginning the hearing at 2 p.m. promptly. So a lunch recess at this time. Thank you.
Thank you, Governor. Oh, God bless us, Mary. Wait,
God bless us one and all.
yeah, we might be live on YouTube right now, just so you know.
I knew that.
Yeah.
Could be. Whatever.
My hair is, I try so hard with this hair and then it just goes by itself.
It looks good.
Oh, thank you. I can't tell anymore.
As it's Alex, just wanted to remind you that we are live still.
Thank you.
Just in
The
case.
public gets to see my hairdo.
Exactly. But we will be beginning shortly.
That's all right. Thank you for your work.
Thank you, Alex. I'm gonna mute
We're going to you
myself.
next.
I'm gonna mute myself before I get in trouble.
Oh,
Well, no, I think we're going to you first.
Well, let me get set up here.
Okay, it's 2 o'clock. 2 o'clock. Okay. We are resuming the Governor's Council hearing of Governor Baker's nominee, the Honorable Judge Serge Georges. And I would like to now recognize Councilor Hurley for your questions.
Thank you. First of all, we spoke at some length prior to the hearing today, and I asked a lot of questions that I'm not going to repeat because they've already been asked by other people. One thing I wanted to clear up for the Supreme Judicial Court application and the nomination, there was a special, and I don't believe Councilor Devaney knew this, there was a special SJC committee that was put together, and the membership of that was 13. And because of the COVID restrictions, no more than 10 people could be together. But the other 4 were there on Zoom, isn't that correct?
Councilor Hurley, I don't know if she was referencing when I went through the JNC for the appeals court application. I thought that's what she was asking, not the SJC JNC. So
it was. I thought it was the SJC JNC because, as you indicated, you never went before the JNC on the appeal.
I did. I went before both bodies.
Oh, you did? Okay. All right.
I did. Yes.
All right. And a constituent of mine, Brian Steely, asked me to ask you if you have ever had any pro se litigants appear in front of you. Being a district court judge myself, I know the answer is going to be yes. Is that correct?
That's right, Counselor. Yes.
And did you ever find in favor of the pro se litigants?
I did, and that's a function of sometimes what I did before we got the standing orders on the revolving credit accounts. I had my own order that I would order the plaintiffs in those cases to turn over the chain of title documents with respect to how they came to own the account and had certain discovery orders that I ordered. And part of that was in kind of to balance the kind of scale about the discovery that would underscore proving the claim. And so there were instances where they could not. And so that would obviously bring an issue as to whether or not they could actually effectively recover a judgment after a verdict. And so those cases would ultimately end up being dismissed because they couldn't provide those title documents.
Very good. There's also been quite a bit of discussion in the last few weeks relative to predatory lending and phony foreclosures. And as it relates to that, did you ever have any of those kinds of experiences? I know when I was in district court, we would have people come in and say that, they were the owners as a result of an assignment and all this other stuff. And, they wanted to evict the people. And I had a way of dealing with them where they'd have to prove all that. And at times somebody would come in with a deed or a foreclosure document from the registry, but it really didn't prove anything. And I'd send them back to where they came from. So did you ever have any experiences like that?
I did. Similar to you, I had the same kind of practice before they were codified in the rules about proving the chain of title and whether or not they had standing to bring those suits. So, and I didn't look at it in terms of kind of putting my thumb on the scale. I looked at it more in terms of if this were to go to a default and they would be back in front of me, perhaps looking for an assessment of damages, it would still be incumbent upon the court to make sure that that was properly predicated on liability. So that means I necessarily had to look at whether or not they had proven their case and they had standing and they had all of the other bases covered in order for the court to enter judgment. So in doing that, yeah, I would see the title documents, and I would say, particularly when revolving credit cases where they did not want to give us the full list of the bill of sale and all of the accounts and all of the things that would connect the dots between the original account holders and the current plaintiff before the court. I would have to be sure that those dots were there for me to be able to connect them. So I would do the same thing that you did.
Also, did you have any experiences with people who came in and you see the ads on TV, people who have annuities or other types of monthly payments as a result of an automobile accident or an insurance policy or whatever, and there's ads on TV.
Yes.
Need money now, such and such a company can help you, that kind of thing. Did you have any experience with those?
A lot. And I'm very proud of the fact that several years ago, I believe it was maybe 4, it became such a concern that we had a judge that was in the Boston Municipal Court at the time, Ernie Saracen. He and I did continuing kind of educational mod at one of our, it was either the spring or the fall conference to talk about structural settlements and to talk about these are one of the limited cases where the judge gets to impose their discretion about whether it was in the best interest of the transferee to order this transfer. And so looking at so I again started to kind of see some patterns that I wasn't happy with. I would see things like consent to a venue, where I would go a little bit deeper to see whether or not there was even proper jurisdiction in the court and ask questions about whether or not there had been other structured settlement petitions that had been filed in other courts that we weren't being made aware of. And I would put in situations where I would deny the transfer in the order that should they go to some other district court or some other division of the Boston Municipal Court, that they had to make the presiding judge aware of all of the prior transfers that had been done before, because in a lot of cases you would see that. And again, it's a civil case. And, in large part, some people might say, well, why should the court get in the way of a litigant that wants to transfer these assets. But statutorily, the presiding judge has that authority if they find that it's not in the best interest. So when you see some of the back end interest that was being charged, you see the amount of future payments, and you see the payments that have already been transferred, it raised serious concern, particularly if the people still had underlying medical conditions and the structured settlement was as a result of a personal injury settlement. They still might have complications in the future, and they might not have any money to pay for it because they transferred it all.
And I think you're absolutely correct on that end. And I just hope at some point maybe a case gets up to the SJC that involves this, because I find it another kind of predatory con game where people sell themselves short, and the percent I would calculate out the percentages of what they were actually getting by that payment.
Mm-hmm.
And it was usury in some instances, in terms of what they were losing. The governor is not often wrong, but in this case, he was wrong about the fact that Boston Municipal Court is the busiest court in the state, because Springfield District Court, as a matter of record and statistics, is the busiest court in the state. That being said, I think I told you how disappointed I was that no one from my district, and we've always pretty much had representation on the Supreme Court from someone, at least, and at one point we had 2 members of the Supreme Court from Western Massachusetts. I must say that aside from my disappointment over that, I am also thrilled that a district court judge is being appointed to the Supreme Court. And in the last few hearings that we've had, I've made people promise that they're going to take a look at the district court cases through the eyes of a district court judge, because they just don't get it that we're the court that has the volume, and has to make split-second decisions affecting people's lives because of the number of people that we deal with on a daily basis. In Springfield District Court, there were days that I had over 100 pretrial conferences to deal with, and an arraignment session that lasted all day long. And in some instances, we had to have another judge whose session had broken down come in and help with the number of bails we had. So the fact that you're going to be looking at things through those eyes and can be, I'm not going to say an advocate, but perhaps an ombudsman that can basically look at the situations and give a new perspective as to how that judge came to that result, or why that judge did whatever they did in the manner or fashion that they did it, I think is going to be of significant help in having the court render fair and just decisions. So many of the questions I was going to ask have been asked. And I think you're going to do an outstanding job. And I hope that you and your wife can be as great a parents as your mother and father were. That whole generation was amazing in terms of the sacrifices that they would make for their kids to give their kids a better life. So if you're half the parent you are a judge, you're going to do a great job there too. Thank you very much, and I appreciate your time.
Thank you, Counselor, and I appreciate your words. Thank you.
Counselor Hurley, thank you very much. Appreciate your line of questioning. I'd now like to recognize Counselor Iannella.
Thank you very much. I don't have any questions. We had a lengthy conversation on the phone. From the folks that I've spoken with, I spoke with, obviously, prior today, Howard Cahalis. Bill Nealon. I understand you worked with him.
I did.
They give you the utmost praise. I mean, you're fair, you're compassionate. I mean, you just are a super, super nice guy. I mean, these people think the world of you. And from what I know and, you know, your presentation today, it's good to see your family here and the witnesses were great on your behalf. I think you're going to be a great addition to the SJC, and I'll be more than proud to vote for you next week.
Thank you, Counselor. I very much appreciate that. Thank you.
Thank you, Councilor Ionella. I'd like to recognize Councilor Ferreira.
I would like to echo the sentiment of my my friend Councilor Ionella. You and I spent several hours together the other day. I come from a different walk of life than most of the people on the council. I was a cop for 30 years, chief of police, been a lawyer for 28 years. I think I'm a good gauge of character when I see it. And the second I met you, I thought you were an honorable, outstanding citizen. The one time I've been to the BMC court, I had to ask Councilor Kennedy to assist me in getting there because I didn't know how to get there and the right court to be at. And I sat in your session in Dorchester. I'm sorry?
He told me that story.
I went to the wrong one twice. So I said, can you please tell me which BMC I'm supposed to be at to help this client? And he was kind enough to direct me. But it was different than the Fall River District Court, the New Bedford District Court. The people you dealt with, but your demeanor was extraordinary. The way you dealt with those people, making them the most important people in the room, the grace that you showed them, the humility. And then when you and I sat a few days ago and you shared your story, and it's hard to articulate, but I just think you just have like a great heart and soul. And I think and I hope that we are going to be friends for a very long time. But, you know, being a cop for 30 years, I had different questions for you than other people did. And now I'm a defense lawyer. You know, I've seen both sides. And I just think that at the end of the day, the best I can say is you get it. You get it on every single level. As a proud dad, as a proud husband, as someone who's a Dorchester guy in and out, who bought pizza by the slice like I did when I was a kid and sometimes still do. But you just get it. I think you're going to be an incredible asset to the court. So that when you make decisions and you're in conferences and you're in deliberations, you're thinking about how this plays out on Monday morning in Dorchester District Court at 9 a.m. when there's 125 defendants sitting in front of a judge. And that's just incredible. I can't think of a better selection than you. And believe me, I've been here now for 6 other appointments to the SJC, and you're number 7. And I've only been here for 6 years, which is historic. Hasn't happened, I think, since 1780 when John Hancock was the governor. That a governor gets to nominate and we get to vote on the entire bench of the SJC. Historic. Congratulations. I think you're a tremendous asset. I think the governor's made unbelievable choices from different people from different walks of life. But I think you're one of the most important. You know, we put out a lot of Superior Court judges and people that have done intellectual property law and everything else. But at the end of the day, 95% of the litigants from the district court, and that's the only court they ever know, will ever know. And you're going to make a tremendous impact. And I thank you for your service. I know, and this is something else I'm just going to end with. Councilor Duff touched on it earlier. It's public service to the nth degree, because you have, and you could be making a lot more money in the private sector. And yet you chose this path to help others. And I commend you for that. And I thank you for your service. And I am ecstatic to vote for you next week.
Thank you for your sentiment and thank you for your support, Councilor. I really appreciate it.
Thank you, sir.
Thank you, Councilor Ferreira, for your perspective and for your kind words. We'd like to recognize Councilor Kennedy.
I'm on the fence. I'm kidding. Just a couple of quick things. We've sat down a number of times over the years, and I've seen you in court a number of times. You a home run. There's nothing to talk about. And, you know, I want to start not just talking about you, but just in general with the 3 nominees that we've had. And I want to congratulate the administration for the fact that they really found we're going to have the most diverse Supreme Court in the country, I think. And I think that's really important. And I think it's also important that we have the perspective, and that's not the only reason you're here, but that we have the perspective of a Black man on the Supreme Court. Because you do have a different view of the world where you were brought up, and from that perspective, just like I do as an Irish American. And I think it's important that we have that perspective. And I congratulate the administration on the diversity of the candidates that they put up, including yourself.
Thank you.
Now, just very quickly, I've gone over these things with you before in terms of the issues I have, and they're mostly related to the pandemic and what's going on to the court in the courts. They're not really questions, just things I want you to think about, okay? I don't think I think we're doing a great job, and there's a lot of really hardworking people doing a great job in the courts. I've seen how hard they're working to try to keep things moving under very difficult circumstances. So the things I'm saying are negative don't reflect on the people trying to do the work. I think they're doing an incredible job, especially when it comes to technology. As I said before, if you told me in January I'd be doing hearings on court by Zoom, I'd say, what was Zoom? I wouldn't know. And I spend a lot of time doing it now. But there's some flaws that have to be looked at, okay? In terms of the technology side, I pointed out to the presiding judge in Dorchester, I spent about 2.5, 3 hours sitting on the phone in Dorchester. Nobody knew I was there yesterday. That's a problem, that just in terms of calling cases and people's time management. That I think the bridge phone stuff doesn't work. I've had a lot of disasters go on with them. And I think if we're going to do it, we do it like this, where you can see who's there on Zoom. And I think it makes a big difference. People doing restraining orders, I'm sure you have on the phone. I don't think that works. You can't assess people's credibility. So when you're looking at things as in your superintendent authority in terms of how to handle this pandemic, I think you should consider that when you're up there, that we got to do it the right way, not just do it the expedient way. Now, that said, I think we're doing a not so great job on the health side of it. Courts are closing every week, 2 or 3 times a week. South Boston, I heard on the news today, closed for a couple of days because somebody tested positive. I heard there's an issue in Dorchester with somebody testing positive, and they're closing down for 2 days to clean up, to wipe things down. That's great. But the problem is it's the people that person came into contact with. And we're not doing any contact tracing in the courts at all. If I went into Dorchester Court tomorrow, unless you happen to see me there and remember I was there, nobody's calling me to say, hey, so-and-so tested positive. And I think you have to look at that. I think that's a big issue that's going on, that there's zero contact tracing going on. And the CDC guidelines say when somebody tests positive in an environment, everybody's supposed to quarantine for 2 weeks. Well, somebody's testing positive on Monday, everybody else is at work on Thursday after they wipe things down. We're not even following the guidelines. That's a problem. Just something for you to think about. And the next thing I'm just going to bring up in terms of evidentiary motions and trials and things of that nature, I don't think anybody's trying to force anybody to go to trial on Zoom. But there are a lot of judges in Superior Court that are trying to force lawyers to go do motions to suppress. I personally think, and I've been doing this for 37 years, that it's ineffective assistance to counsel to try to do a motion to suppress over Zoom. You cannot cross-examine a witness. Would you agree with that?
That you can't effectively cross-examine a witness?
Yeah, on these.
I have to tell you that I do agree with that. The question about what that you're asking, though, is if there are constitutional implications that attach to that. And I think that becomes the issue and becomes the question.
Well, if you're ineffective, it becomes a constitutional issue. If you don't have effective assistance of counsel, right?
If you go back one domino, yes. The question about before trial, whether or not you have a constitutional right to confront and cross-examine the witnesses at the motion to suppress. And I can certainly see from a lawyer's perspective that as a matter of colloquial kind of definition, yeah, I need to be able to see them. I need to be able to assess their demeanor, see how they move around as I question them.
Now, I don't want you to answer the following questions because it's coming before you next month. You're going to get on. You're going to be voted on next week. You're going to be on the Supreme Judicial Court. But I just want to point out to you the situation that lawyers like me are being put in. We're being told you can come in on and do it on Zoom, which I think is ineffective assistance, or you can come in person and do it. We'll give you that option where you're putting you or your family's health at risk. So you're being left with the choice of being ineffective or putting somebody at risk. And I don't want to have to say to Judge George, I don't want to do it because my mother-in-law has diabetes or my wife has X, Y, and Z. I'm healthy, but they're not. I shouldn't have to do that. And I shouldn't be put in a position where I have to make that choice. The last thing I'm going to say about that is there's a light at the end of the tunnel. 6-8 months from now, we're going to be done with this. And if a larceny case or a first offense driving under doesn't go to trial in the next 6 or 8 months, the sky is not going to fall. We just have to be patient. And those are issues that you're going to have to deal with when you go up there. And you have to deal with those right away, especially the health issues over the next 6 to 8 months. And I just want you to think about that. Okay. I read an article the other day that the SJC that the governor put on, the 7 judges, are going to be, I guess, more timid than it's been in the past, that it wouldn't be bold. Okay. I hope that's not true. I hope when you go up there, you're really bold, that you make important decisions, like the decision dealing with marriage equality that you referred to in your opening. That was a bold decision. And I hope that you continue to do that when you're sitting on the SJC. That said, Matt Mashera called me at least 3 times. Okay, Judge Mashera. Judge Sorensen sent a letter in as well. I got one at home from him, as well as I've gotten countless phone calls. I want you to get on and be done with this because I'm tired of getting them. And I'm tired of seeing your picture in the paper every other day.
So am I.
Huh?
So am I.
But I'm voting for you next week. Thank you.
Thank you, Councilor Kennedy. I really appreciate it.
You're going to be great.
Thank you.
Thank you, Councilor Kenny, and thank you for sharing your experiences in the court. It is important for Honorable Georges to hear. I would now like to recognize Councilor Jubenville.
Thank you, Your Honor, and Your Honor. I don't think you're going to have any problem being bold. No one has ever told me they've been able to push you around in the court system.
I hope not.
And you're big enough to withstand it. Gaziano may give you a little trouble because he's a former football player, but I think you'll be great up there. We had a pretty good talk yesterday, and I'm going to go over very briefly the issue with the study done by Judge Gantz, only because he asked to have it done and he's not here now. And I think it should be brought up at every hearing that we have for a while. And as I said to you yesterday, all the pages in this study, they only found one answer to everything that was going on in our court system concerning this issue: systemic racism. That was their answer. The study found 655 out of 100,000 black people in Massachusetts are in prison. The state locks up 82 of its white citizens per 100,000. Locked up at the rate of almost 6 times the rate of white people. Black people get more severe charges, harsher sentences. What they found was a criminal justice system which is unequal on every level. Every level. Police stop black drivers more. They're likely to be searched more. They're less likely to get plea bargains or pretrial intervention. Black and Latinx people receive longer sentences in the Superior Court. They get sentenced to minimum mandatories more than white people. They're more likely to be incarcerated and receive longer incarceration sentences than white people charged with similar offenses. On the average, they do 168 days longer than a white person for the same charges. I'm reading this little thing from an article I received. Racism may well be the biggest crime in the criminal legal system. If present trends continue, 1 of every 4 African American males born in this decade can expect to go to prison in his lifetime. 1 in 4. Since the Brown versus the Board of Education was decided in 1954. 1954, in that case, overturned Plessy versus Ferguson, which was decided almost 100 years before that. Separate but equal. Took 100 years to change that. But it said since 1954, in that case, about 100,000 African Americans were in prison at that time. Now there are approximately 800,000 African Americans in jails and prisons, 538,000 in prisons, 263,000 in local jails. Black men are nearly 6 times as likely to be incarcerated as white men. A couple other statistics. In our criminal justice system, police arrest approximately 14 million people annually. 65 million people have criminal records in this country. 2 million of them have been in jail at some point in their life. On any given day, federal, state, and local jails hold 2.3 million people. These are all approximates. In addition to that, there's 3.7 million on probation, 840,000 on parole. Almost 7 million people are enmeshed in the criminal justice institutions. The institutions employ 4.3 million people, our criminal justice system, including police, guards, and other capacities, at a cost of hundreds of billions of dollars a year. 2015, 31 American states had the highest incarceration rates per 100,000 in the world. 38 states in the United States locked up more people. Each state locked up more people than the entire country of El Salvador. % of the women locked up in the world are in the United States. 30%, even though our population is a lot less than that. African American women, the rate of incarceration is twice that of white women. In 1950, 23,000 correction officers were employed in all the United States jails and prisons, and the state and prison system in each state. Today, there's over 700,000 plus working for the correction systems. Massachusetts imprisons more people per population than any country in the world, except for Cuba, Rwanda, Russia, El Salvador, Azerbaijan, Panama, and Thailand. We lock up about 377 people per 100,000 in Massachusetts. So with all of those figures and what this study from Harvard Law School says, how in God's name is anybody that's a minority in this country think they're going to get a fair shake in our court system? How would they do that?
I don't know that the issues that plague society in general won't have some presence in the court system. if we haven't been able to figure this out on a societal level, people in society are the people that work in the court. So that has to exist, and I don't dispute that. The issue that I have is, as I mentioned during our conversation, when you say systemic, that means everything. That means all.
Yeah.
That means the defense lawyers like you. That means the judges like me. That means the district attorneys like Rachel Rollins. It means all. And from my perspective and what I've seen, although I don't dispute that maybe it exists somewhere other than where I have seen, what I've seen are the people that try to get it right every day, that do as we were talking about the other day when Paula Carey and I believe it might have been Harry Spence at the time, when they said, you know what, we want to give training, we want to give the judges tools to understand that perhaps there are some implicit, if not explicit, biases out there that may bleed into the decisions that they make. And we have a statewide education to try to get people to understand that maybe you're not aware of some of the things that are going around that go into your decisions. But Councilor Juville, I can't tell you that I'm not proud of the people that I work with, that I see every day trying to make the best decisions that they can for the right reasons. I can't tell you that. You ask me, how is somebody supposed to get a fair shake? Go in front of Jim Coffey. Go in front of Lisa Ann Grant. Go in front of Jonathan Tynes. Go in front of Ken Fiandaca. Go in front of David Weingarten. They are going to get a fair opportunity to be judged for who they are, not what they look like or what the color of their skin is. Notwithstanding the fact that it's there. I can't dispute that. But I also mentioned, you mentioned one of the statistical issues in the Harvard study. You mentioned the Superior Court. Did you happen to see the statistical information coming out of the Boston Municipal Court?
I did not.
Well, there is no statistical difference of the defendants that get sentenced in the BMC, white versus black.
No difference.
There's no difference. So when you look at it and you say, are we perfect? No. Are we trying? Yes. Are we committed to trying? Yes. But can't we all do better? We can and we should. So again, it exists, it does. But I do say that there are a lot of good people that are trying to do the right thing every day. And that might not be popular to say, but it needs to be said.
I don't disagree with you. I see it when I go to court. I'm in court just about every day, and I see it.
I know you do. And you've told me yourself.
Yeah.
You've revisited the way you see things and the way you think about things.
No question
about it. And that's hope.
It is hope. You look not only in Massachusetts, but you look throughout this country at these figures. And if I'm a member of a minority class, man or woman, and I read all of this, I'm not going to be too confident about going in any court building.
Mm-hmm.
I'm going to say, holy Jesus.
Yeah.
And I guess you don't probably have any answer because of how it happened and how it got to be this lopsided. Maybe there's built-in racism that we don't even view. We don't even understand because we're so used to doing things for so long away. I mean, don't forget, the court system's been around for a long time.
Right.
And it's very difficult to change things in our system, as you probably well know.
You do.
And the answer is, when a change is brought up or some way of doing something is talked about, doing it differently, the answer is from higher ups, well, we've always done it that way.
Mm-hmm.
Maybe that's the problem. Maybe we need from the top down a shakeup on everything we do to see what happens, to see whether that somehow cuts these figures down to a way that they should be.
Absolutely.
I mean, I don't disregard the figures because they're figures involving human beings. And have you ever been inside of a jail?
I have.
Okay. So you know a state prison or a jail, you know what you see when you go in there. And I used to go into the state prisons a lot many years ago. I used to always say a prayer. My prayer would be, please God, don't let me do something that I end up in here. Because it's an awful place to be.
It is.
So anyway, I have no doubt when you're on the high court, these issues are going to come before you or be talked about. And I'm confident that you will be a voice for all these people that are incarcerated and all of these people that may end up going to jail. And some of them have to. No doubt about it. Let me ask you a couple of things here. Oh, by the way, I got a call from Judge Tommy Horgan this morning. I was almost late getting here because he kept me talking while I was supposed to be getting prepared to leave my house. So he is in your corner 100%, thinks the world of you.
I appreciate that. My BMC colleagues, my family, have been incredibly supportive and encouraging, and I'm really pleased to be representing them.
Yeah. We always ask this question, one of us. What's your opinion about minimum mandatory sentences?
I don't like them. If the legislature thinks that it's a good idea and I have to follow that, but I do like the fact that when you think about what's the appropriate thing to do, that a judge has the full range of what they can use to do what's best in that situation. And I think anything that hamstrings a judge's discretion to be able to do what they think is right in that circumstance, I'm not in favor. I'll follow the law if that's what they say, but I'm not in favor of them.
Well, the legislature has set out, for many years, there was no minimum mandatory sentences. And they came about, for the most part, in my view, from some horrific crime that happened. And it got a lot of publicity. And politicians get on the soapbox and scream for tougher laws to make things safer for the community. And I think a little of it was they would be noticed doing that and get reelected. So we end up with these laws. And the hands of the DA decides who gets charged with them or not. Sometimes it's a close call and they get charged with it. But my way of thinking is especially where, not so much you, but everybody that comes here says, I'm going to be fair. And my question is, well, if you were sitting in court and somebody's charged with a crime and they're going to get penalized in a certain way, like for a minimum mandatory, and you know as a person and as a judge, that is not a fair sentence in this case. Would you still do it? Of course, people say, yeah, I got to follow the law. And I say, no. Judges don't follow the law. You made a comment earlier, I heard, which is true in my view of what every single judge in this system does, with the exception of the appeals and SJC to some extent. Judges interpret the law. They don't follow it. In 2 courtrooms in Dorchester, we can have one judge with the same set of facts, same defendants, come up with 2 different interpretations of that law, right?
I can agree to an extent. If we're talking about the interpretation of whether or not there is a breach of contract or there was some conduct that constitutes an assault or some legal definition, that is one thing. If we're talking post-dispositionally and they say if a jury has spoken and you have been convicted, and if you're convicted of this crime, it says this is the minimum sentence that you may impose. I don't think that's interpreting. That's following what the legislature said.
That I agree with you. I'm talking about following the law as to whether somebody should be found guilty or not guilty, or somebody's motion should be allowed or not allowed.
Agreed.
In different courtrooms, different results.
Right.
That's why we have appeals courts and SJC to review these things. If everybody followed the law, we wouldn't need you guys. But but people don't. They interpret the law, and that's what's good about our system, I think.
It is. A judge's discretion, it is.
Yeah. But to me, a judge can say, I'm not going to follow that law. It's not fair in this case. It's nice, and I swore I'd be fair on this bench, and I'm not going to follow it. I'm going to give the person a sentence outside the minimum mandatory. Now, we both know it's not going to last, but it shows you did it.
Mhm.
And if enough judges did that on some inappropriate minimum mandatory, the legislature would change it. And for those up in the high courts, I would think an argument could be made, if it was that unfair, it would be cruel and unusual punishment for the crime and the circumstances.
Mhm.
No.
Well, whether you're error correction court or your court of last resort, you get what you get if it comes before you.
Yeah.
If it hasn't come before you, it won't be decided. But
Right.
somebody may make that argument, and at some point it may have to be a discussion that the SJC or the appeals court has to have.
Yeah.
It's a difficult situation because you just mentioned there have been instances recently where there have been Superior Court judges who have said that they're not going to impose the mandatory minimum, and it has gone up and it's been reversed.
Right.
And so I know you know that it's a difficult situation when you are a trial judge and you want to be respectful of staying in your lane, as Article 30 says that you do, with perhaps thinking that this might not be the most fair result. And it's a terrible situation when you're in there.
Yeah. Yeah. And I wouldn't want to be sitting there and have to make that decision, but I think like Kennedy, Counselor Kennedy said, I like judges who are bolder and they go out of the box because it opens people's eyes. People talk about it. And the judge that did that in the minimum mandatory case, people talked about that. Oh, geez, what a gutsy judge to do that. We all know what's going to happen, but she spoke out about it because it wasn't right and she wasn't going to do it. Judge Harrington in the federal court for years refused to sentence anybody under those guidelines. They were so draconian. And I don't know how much of an input he had, but they changed them. They made them advisory.
Mm-hmm.
And I doubt whether they would have got changed if judges across the country in the federal system didn't do the same. Criticize them and not sentence people under them. So maybe that's a place. Yeah, speaking of guidelines, I don't like guidelines. Legislature's never approved them. The legislative body is the one that approves how citizens are punished for a certain crime. Guidelines to me are used by the prosecutor when they benefit them, or the defense lawyers when it benefits them. And although it's not mandatory in Massachusetts, my own experience is, as soon as you go for a plea or sentencing, I don't know how many times I hear from the person on the bench, what's the guidelines? I don't know, so what? What are you going to do, Judge? You know what the law says, you can sentence a range of sentencing. But they default to the guidelines. And that's where the conversation begins. Where it shouldn't, in my view. Because one size doesn't fit all. All right, were you on the commission that did the guidelines?
I was on for a bit with the commission that was run by Judge Jack Lew.
Okay. But I haven't seen any data that says a person in Boston should be sentenced to a certain amount of time and the person in Springfield should get the same sentence. They're two different people.
Mm-hmm.
So I don't go them. I keep asking judges not to use them or not even to bring them up, but they do. Some don't, but a lot of them do. Judge Harrington, you said I'm going to sentence people, judges have I'm going to use things to sentence people that judges have been doing since we've had a court system. And he listed out a bunch of things. The defendant's qualities, the crime, whether somebody was injured. He took into account all of those things. He said, they work as good today as they did 50 years ago. And I think the court system is trying to make it easy and to pigeonhole everybody in a quick way to get sentenced. Guidelines say 3 years, that's what you get. It's a safe fallback for a judge. They give a sentence under that and something happens, they get criticized. Anyway, that's my take on guidelines. And judges, in my view, shouldn't have to worry about criticism. Do you think they should?
I don't think they do.
Yeah, most don't.
They know they're going to get criticized, and that's part.
Every decision you make,
Right.
one side is happy and one side isn't.
So, and sometimes somebody in the middle.
Yeah. It's like people say, they always use the term, I want justice. I don't know what that means anymore.
Can mean different things to different people.
In every courtroom I've had trials, serious trials, there have been a lot of people for both sides, the defendant's side, the victim's side. Whatever the verdict was, half of that room didn't get justice.
Right.
So I don't know what it means. The only thing I tell people is the only thing you're probably going to get in the system, most of the times you will, is a fair trial. That's the best we can offer you. Can't satisfy you in some ways.
Mm-hmm.
Even when you lose, even when you win, you get a not guilty. It's cost you a fortune. It's changed your life for a year, maybe 2 years. No winners in those courtrooms, no matter what. Just a couple of quick things. I brought it up last time. Psychiatric evidence. You ever have any of that in your courtroom?
Not in terms of experts coming in to talk about criminal responsibility. Yeah. The case is usually resolved before it gets there.
You're lucky.
Well, I know that there are a lot of folks that think that it's a net sum zero because you're going to have one person on one side say one thing and one person on the other say another. But it's important evidence, it's relevant evidence, and I think if the question is whether or not a jury shouldn't be able to consider relevant evidence, all of the evidence is relevant to one person, and maybe the other person is just going to say it's irrelevant.
Yeah, but psychs seem to be able to come in and take whatever position they want. And there's no way you can dispute it. It's not like the doctor's testifying about broken femur. There's a break. We know that. Doctor looks at a patient, asks him questions, says, well, I've decided this. Most of the time, it's on who brings him in the courtroom. On these SDP cases, there's always 3 on each side. Usually the same 3 in case after case after case. And the 3 on the defendant's side are getting paid by the Commonwealth, probably. 3 on the other side from the state, they're getting paid. And they take the same positions. Maybe we should have 5. So we have one tiebreaker. And then if they get hired for the other side, they come in and espouse the same thing, the different scenario that they just talked about in the courtroom the other day and said it was the other way. And there's nothing you as a judge can do or I as a lawyer can do. It's all up in their minds.
Well, there's a little bit that we can do. I mean, don't we have to have a Dober-Lanigan hearing before that to make sure that the expert has something to say of value to the jury that's relevant and that's probative of some issue in the case? again, the idea that it's not necessarily, we talk about the issue of it's not a wall, it's just a brick in the wall. And
Yeah.
so it's just a piece of relevant evidence. I can see how frustrating it is that you might say it's just a battle of experts, so why should we just let them both cross themselves out and not have them at all? But we said one of the things that you said a few minutes ago, that you think, in your opinion, the one thing that we can give you is a fair trial. And if the one thing we can give you is a fair trial, isn't it important that the jury have everything that it can to get as much good in, to get as much good out? And that's a piece. It is a piece.
Yeah. Just a couple more things. These things are on my plate recently, and I was talking to the judges here about it briefly. Probable cause hearings.
Mm-hmm.
7 years you've been sitting in Dorchester. How many probable cause hearings have you had?
One.
One. And it's probably because the DA wanted you to resolve the case.
It was because I wasn't going to give another probable cause.
Oh, okay. Okay.
So they were either going to have to go, or there were going to be a Perkins issue.
Yeah. We either should get rid of that or make it real. Instead of the DA, well, we're not ready yet. We got to go to the grand jury. Somebody else has got the day. I got to get this day. We continue these things 2, 3 times, 60 days, 90 days. And I say, well, Judge, it's not that we're continuing. We're never going to have one. They're not going to let us have one. And even if you find no probable cause, they'll indict him the next week anyway, which they can do. So let's stop the charade here in these courtrooms. It's on for a reason. You don't need much for a probable cause hearing.
Mm-hmm.
One police officer could come in most of the time and do it. But anyway, grand juries. I think to make things transparent, to make people believe in our grand jury system, because it doesn't hold a good reputation. The old saying, they'll indict a ham sandwich. The DA can indict a ham sandwich if he wants. Probably true. My feeling is, why do we have DAs in the room? Why don't we have lawyers that are employed by the superior courts that are trained and handle grand jury minutes? Tell the grand jurors all their rights, what they can do. And that way, it doesn't look like the table's tilted. What do you think about that? Having independent people running the grand jury?
Isn't that a matter of legislative enactment?
It is, but they could get a good kick in the rear end from the Supreme Judicial Court about it.
I think, if you wouldn't mind, I'd like to take the fifth on that one.
Yeah, okay. Dangerousness hearings.
Yes.
You think they're being overused?
I think the concern always is that it's an appropriate use of the power that they've been given by the legislature.
Yeah.
And I would hope that even though there's a prescribed list of crimes, that whomever it is that's making a decision is making a real decision as to whether or not they really thought that this person was dangerous to the point that they should ask the court to hold that person without bail. That obviously is going to be a fact-intensive kind of analysis and consideration. But what I don't like to see I don't like to see indiscriminate use of holding people without bail. Obviously, this is an incredibly important thing because you always have to remember that these people haven't been convicted of anything. So if you're going to be asking for that and potentially have that relief be granted, the hope is that the ask is based on a real concern for public safety or for a particular individual, that it's just not a matter of rote chorus, that it happens to be a gun, so I'm going to move for dangerousness. It happens to be a domestic issue, so I'm going to move for dangerousness. That isn't, at least I would argue that that's not the kind of discretion, that's no discretion at all. That's doing it every time. So there isn't any exercise of discretion in that case, and there should be.
Well, I don't see the logic in saying somebody's a danger to society. You got to hold them for 4 months. the end of the 4 months, he's entitled to bail.
Mm-hmm.
Well, did he become better sitting in jail? Now he can be put on a bail? Is that dangerous? Why wouldn't he be held forever until they had a trial?
Well, outside of the circumstances that we found ourselves now with the pandemic, the expectation of the legislature was within that dangerousness period, that held without period, that the matter would be brought to trial.
Yeah.
And I understand that that might seem like it's a little bit pie in the sky and in concept only, and we're just holding folks without right now as a matter of kind of punitive detention. But that is the expectation of the statute.
Yeah. And one part of the statute that I think is just terrible is the fact that they've tied it to the Rule 36 exceptions for tolling it.
Mm-hmm.
And that way, I think I might have told you, I have a woman that's been in jail now 15 months.
Yes.
And she can't get out because the COVID came, and because things aren't getting done because of COVID, she has to stay in. So if COVID's around for another 3 years, she doesn't get any credit. She stays in there for the 3 years, which I just think is unfair, completely unfair to. I thought part of the deal with the dangerous was to keep somebody to cool down the situation a lot of times, get them away from people, calm it down. Then in 4 months or 6 months, he'd be in a better position to, okay, we're going to let you go out. If you screw up, you're coming back. But to hold somebody and told the statute every time their lawyer files a motion to suppress, I just think isn't what was meant by the legislature, or they didn't think it out. But in any event, so I had the pleasure of being in your court many times. I spoke at your drug court, wonderful day. I could see the people in that court just really, really respected you, and just it was amazing to see the way they behaved around you and how much they liked you for what you did. I think that's worth an awful lot. You introduced me to some people of these people, and they were just so high on you and what you did for them, and gave them a new start in life. It was something I think everybody should see. That was just wonderful.
I appreciate that. Thank you.
And many times I've seen you in the court. I had never seen one thing I could ever criticize you on, and I never heard you being criticized by any DA or any defense lawyer. Never. That's not always the case. But I've never heard one bad word about you. So that being said, I'm not going to vote for you.
Okay.
Again, after this time. Twice is all I'm going to vote for you.
Well, I'm glad, because I just nearly had a coronary and just fell out on the floor.
Because if you come back to us again, we're not voting for you anymore.
Councilor Jubinville, thank you.
It's been a pleasure. It's been a pleasure knowing you, and my life has been better knowing you and talking to you. I think you're going to make a wonderful judge, wonderful SJC judge.
Thank you for your support and your confidence.
100%.
I hope so. Thank you.
100%.
Thank you. And I would have had the second coronary. I just want to thank my colleagues on the council. I always learn from them in every setting. And I know that you listened and learned a lot from them as well. And also from the witnesses who were called here, your friends, and probably more so from those who came to this proceeding wanting you to hear their perspective and their experience. And it strikes me as all of this is something that is just innate in terms of who you are, someone who listens, who learns and contributes, and you're accustomed to this. And I just want to thank you for your patience today in coming and being so forthright in your presentation, as well as in addressing the questions and concerns today. We are now concluding this hearing, And we will convene and assemble next Wednesday on December 9th, when this council will take your matter up for their vote, which will be certainly look forward to. And I just want to thank you once again and your family and your friends for coming here today and participating in this hearing. I also, before we close, just want to thank all of you from behind the screen. All of them have been working very hard throughout these proceedings to make sure that the audio and visual allowed for this to take place, and for many to either watch from wherever they are in the Commonwealth or afar, and also to be able to present their testimony. So I just want to thank everyone in the crew for all of your assistance. To Dean Serpa and Grace Robinson, I also want to thank Bob Ross and Lauren Green from our Governor's Legal Office for all their assistance and attention. Thank you.
Governor, thank you. And thank you to the ladies and gentlemen of the council. I really appreciate the day. Thank you.
Okay, thank you. That concludes our assembly today.